In this public hearing of the Human Rights Subcommittee of the Joint Standing Committee on Foreign Affairs, Defence and Trade for the inquiry into Australia's efforts to advocate for the worldwide abolition of the death penalty. I'd like to begin by acknowledging that we meet today on the meeting place of the Ngunnawal and Ngambri peoples, their meeting place of 1,000 years and more. I'd like to pay my respects to elders past and present and to acknowledge the cultures of any Aboriginal and Torres Strait Islander people present with us today. The hearing will be broadcast on the Parliament's website, and the proof and official transcripts of the proceedings will be published on the committee's website. I now welcome representatives of Amnesty International Australia and Human Rights Watch to give evidence today. For the Hansard record, would you please state your name and the capacity in which you appear before the committee, beginning with Amnesty International?
Mr. Ry Atkinson, Strategic Campaigner, Amnesty International Australia.
Thank you. Could you hear us, Danielle? Yeah. Oh. Can we just, we can't hear you quite, Daniela. We can see you with great clarity, but difficulty hearing you. Nope. Just bear with us a moment, Daniela. We're working on it. We think it might be at your end, Daniela. Do you want to log off and log on? We'll just wait a few moments.
Joys of technology.
When it works, it's wonderful. When it doesn't, it's really not wonderful.
Tell me about it today, Dean.
There we go. We're just waiting for Daniela to reconnect. Shane, here we are.
Can you hear me now?
We can hear you very well, actually. So we extend a warm welcome to Human Rights Watch. If you'd just like to state your name and the capacity in which you appear.
Sure. Hi, my name is Daniela Gavshon and I'm the Australia Director for Human Rights Watch.
Great, welcome to you. This hearing is a legal proceeding of the Parliament. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privileges. I now invite you each to make a brief opening statement before we proceed to questions and discussions. Mr Atkinson, do you have an opening statement?
Yes, I do. Thank you, Chair. And thank you all members of the committee for your time this morning. Amnesty International would like to acknowledge the traditional custodians of country throughout Australia and their connections to land, sea and community. We pay respects to elders past and present and extend that respect to all First Nations people present here today. In Canberra, I pay particular respect to the Ngunnawal and Ngambri peoples of whose land the Australian Parliament is located on. Amnesty International opposes the death penalty in all cases without exception, regardless of the nature or circumstances of the crime, guilt, innocence, or other characteristics of the individual, or the method used by the state to carry out the execution. Amnesty International is a founding member of the World Coalition Against the Death Penalty and joins forces with its members every year to mark the Global Day of Activism Against the Death Penalty on the 10th of October, which I'd note was yesterday. Amnesty International's monitoring of the global use of the death penalty recorded 1,153 known executions in 2023, an increase by 31% from 883 in 2022. However, there was a significant decrease in executing countries, from 20 in 2022 to 16 in 2023. This global spike in known executions was due to a considerable rise in the numbers recorded in Iran, where executions increased by 48% from 576 in 2022 to 853 in 2023. This constitutes approximately 74% of all known global executions. While international human rights law prohibits the use of the death penalty for crimes that do not meet the threshold of most serious crimes, which are limited to crimes involving intentional killing, at least 5 countries, China, Iran, Kuwait, Saudi Arabia and Singapore, carried out executions for drug-related offences. A total of 500 such executions were recorded, marking more than a 56% increase in the number recorded in 2022. In Iran, drug-related offences represented more than 56% of cases, or 481 people executed. And this is the central point I draw the committee's attention to, and one that Amnesty believes has been overlooked in the Australian government's strategy regarding the abolition of the death penalty. Zero tolerance, tough on crime, and other highly punitive approaches to drug policy based on the prohibition and criminalisation of drugs has been implemented in many countries around the world. Yet the implications for human rights have been devastating, particularly for those from the poorest and most marginalised sectors of society. The war on drugs has effectively been a war on people, has undermined the rights of millions and has left a legacy of violence, disease, mass incarceration, suffering and abuse around the world. Current drug policies worldwide are based on an international legal framework embedded in 3 different UN conventions, to which almost all states are party. However, none of these conventions makes any reference to the death penalty. The UN Common Position on Drugs has reiterated in unequivocal terms that the application of the death penalty for drug-related offences does not respect the spirit of international drug control conventions and has the potential to become an obstacle to effective cross-border and international cooperation against drug trafficking. And the point that Amnesty would make is, while not an obligation under international law, that if Australia really wants to achieve the worldwide abolition of the death penalty, it should take a principled position that imposes a consequence on retentionist countries, such as a bar on that cooperation. Yet rather than this principled approach, the statement of intent to the 2018 strategy states that it does not consider Australia's approach to government assistance or police cooperation in a death penalty context. On this, I'd ask the committee to consider the point what the point is of having a country strategy that excludes key areas that relate closely to the success of that very strategy. Other submissions to this inquiry detailing length the concerns around ministerial discretion in death penalty cases, concerns which Amnesty shares. But beyond this, I'd again raise the further concern that ministerial approval is not even required for pre-arrest cases. This practice is alarming when you consider that in Senate estimates, AFP representatives revealed that since the 2021 Myanmar military coup, the AFP has shared 296 pieces of their intelligence in relation to drug exportation from Myanmar. As pointed out by the CPJP in their submission, drug trafficking is not only eligible for the death penalty in Myanmar, but carries a mandatory death sentence if certain criteria are met, such as being recidivist or part of a criminal organisation. Again, this approach by separate Australian government agencies is counterproductive to the intended goals of the 2018 strategy. By cooperating in this way, Australia is essentially saying that the abolition of the death penalty is an important issue to us, but not as important as this competing priority. It sends the completely wrong message, and it would be far simpler to maintain a position that if you impose the death penalty in relation to crimes that don't meet international standards, as a rule, our intergovernmental agencies will not cooperate. This sends a clear message that for effective justice to be carried out in retentionist countries, they must pursue abolition. Thank you again for the opportunity to appear today, and I'm happy to take any questions.
Thank you very much. Ms. Gavson, would you like to make an opening statement?
Yeah, thank you. And thank you for giving me the chance to appear this morning on behalf of Human Rights Watch. Just to acknowledge, I'm actually on Gadigal land. Sorry I couldn't be there in person. And I'd like to pay my respects to the elders past and present of the land I'm on. As you know, Human Rights Watch is a non-government organisation that seeks to promote respect for human rights in more than 100 countries around the world and hold abusers to account wherever we can. For more than 3 decades, Human Rights Watch has opposed the death penalty in all circumstances because of its inherent cruelty. Our submission that we provided to the committee focuses on 2 key issues in Australia's advocacy for the abolition of the death penalty. One is bilateral engagement and the second is police cooperation. I'll talk first to bilateral engagement. As an abolitionist country, Australia is part of the worldwide movement opposing the death penalty. The government has taken a leadership position, engaging in multilateral advocacy and actively using its voice at the United Nations General Assembly and Human Rights Council in relation to death penalty abolition. But these efforts ought to be reinforced with strong, consistent and targeted bilateral efforts. Most of the government's bilateral work in this area is characterised by private engagement, and this has led to, we believe, numerous missed opportunities to build political pressure. In our submission, we spoke specifically about examples in Singapore, China and Vietnam, 3 countries which carry out the most executions by far in the Asia-Pacific region. In Singapore, in 2022, 2023 and 2024, publicly announced executions took place during the 2 weeks preceding the Australia and Singapore annual leaders meeting. Despite this, none of the public statements and dialogues following the meetings mentioned the 55-year-old man who was executed in 2022 or the Malay man who was executed for trafficking 1.5 kilograms of cannabis in 2023. Nor was the use of the death penalty in violation of human rights discussed more broadly. And just last week, Singapore executed 47-year-old Muhammad Azwan bin Bahari for possession of 26 grams of heroin for the purpose of trafficking. He is the 4th person to be executed in Singapore this year. With Vietnam, the Australian government does appear to raise the death penalty during the annual human rights dialogue, but Australia has never set public benchmarks with Vietnam to abolish the death penalty, and we see no sign of its use abating. The Chinese government is believed to carry out the most executions compared to any other country. And while Australia has spoken out about the suspended death sentence imposed on an Australian citizen, given China has a 99.9% conviction rate and routine due process violations, Australia should be speaking out strongly about the Chinese government's use of death penalty, regardless of the citizenship or the nationality of the person involved. As I said, our second concern is police cooperation, and Rai also spoke about this at length. There's a lack of human rights oversight in police cooperation between Australia and other countries. The Australian government's 2018 strategy doesn't cover government-to-government assistance nor police cooperation in a death penalty context, despite assistance often being in relation to drug trafficking cases, an offence which we know is punishable by death in many countries where assistance is provided. Instead, as Rai pointed out, the Australian Federal Police Guideline, or International Police-to-Police Assistance in Death Penalty Situations, is used to assess where police cooperation is appropriate, and this includes sending relevant issues to an internal oversight sensitive investigations board. But the appropriateness of this mechanism remains questionable. There are no required additional external reviews by DFAT, by lawyers, or by human rights experts. Police cooperation should be covered under a revised strategy, and a new strategy should emphasise the crucial role external human rights oversight can play in ensuring police assistance does not make Australia complicit in any executions. And in countries like Vietnam, which continue to impose the death penalty for drug-related cases, the Australian government should consider non-cooperation with Vietnam on drug-related matters at all. So there are a number of recommendations in our submission, but two central ones are first that the government should increase its advocacy by continuing its international engagement on multilateral platforms, but also speaking out publicly in bilateral engagements, setting measurable benchmarks to progress and abolition. And then secondly, the government should update the 2018 strategy to include government-to-government assistance and police cooperation in a death penalty context, with the inclusion of a government human rights specialist on the oversight board and cancelling cooperation altogether when necessary. Thank you, and I'm also happy to take any further questions.
Great. Well, thank you very much for your evidence. I might start with some questions, if that's okay. So I might just ask my questions and invite you both to comment. I just want to start at a high level. Given the sensitivity around diplomatic relations between governments, is it right to assume that the public shaming of retentionist states is non-negotiable, that it's not an option? Because I think there are some powerful examples where retentionist countries seek to avoid scrutiny of their death penalty practices, but in in neighbouring nations, you can see incremental steps towards removing the death penalty. And I'm just wondering how important it is, do you think, for Australia to take the next step and more actively call out the behaviour of retentionist states, even those that might have close and trusted relationships with Australia?
Thanks, Senator. I'm happy to go first, Daniela, if that works. So I think that Amnesty's research has shown that, there is a smaller number of countries around the world that are using execution as a method. And while that number may have become smaller over the years, and that's a continuing downward trend, the commitment of those smaller countries to carry out those executions seems to have increased. But that's not to say that that hasn't happened in many cases with a sense of shame carried around that in the international space. Countries like China, China is the world's leading executioner around the world, while Amnesty doesn't publish figures on China due to, and that's been a practice since 2009 because the Chinese state has misrepresented Amnesty's figures in relation to the use of the death penalty in China in the past, and because we're not able to publish reliable figures, we no longer give a number. But China is the main executioner around the world and executes more people than all other countries combined. And Vietnam as well doesn't publish these figures, and that does come from a sense of I guess shame in the international space. And there has been progress with many countries as well. Several countries in the African continent have made positive moves over 2023 to abolish the death penalty, and Pakistan has removed the death penalty for crimes related to drugs, and Malaysia has removed the death penalty, the mandatory death penalty in some instances as well. So there has been progress, and that continued progress continues to put retentionist countries in a position where they do feel like they, in some cases, have to hide the figures and hide the fact that they are carrying out these executions. So it is important to continue calling out countries and being proactive in this space. And I think Daniela spoke to that in her introduction as well, particularly in relation to countries like Singapore when those bilateral opportunities arise. The issue is that when it's not done consistently and when it's not done in a principled way, countries take issue when they then feel that they're singled out. If the Australian government and, the abolitionist movement, the coalition of an abolitionist movement, approach this in a way that says, no matter what country, no matter what the engagement is, this is what we're going to do. We're going to include statements around the death penalty, and you can expect that from us every single time. Then we don't get to a stage where, when the Australian government wants to raise an issue regarding the death penalty, retentionist countries feel singled out and there's possible impacts to bilateral relationships, as you referenced. It needs to be a principled and consistent approach.
Thank you. Ms. Gaveston?
Yeah, thanks. Thanks for that. And, I agree with what my colleague from Amnesty said. I think, one of the things we said in our submission specifically was that we do believe sustained political pressure needs to happen at every opportunity, unless there is a risk assessment that determines the public advocacy will do more harm than good. So, we do accept that there may be situations where it could do more harm than good, but that should be the exception, not the rule. One of the other things as well, Rai also mentioned how he referred to Singapore. I think when a country, when Australia speaks strongly about abolition of the death penalty and has a strategy and speaks strongly in multilateral fora, but then when it is in meetings with Singapore and, you have someone being executed 2 weeks before or a week before or a week after, it just shows that sort of, I guess in a sense, it doesn't show that the issue is being taken as seriously as Australia should be making it seem like it's taking it. So I think that it sort of seems like it's pushed to the sidelines for with the intention of sort of focusing on the diplomatic relations, but not actually having the hard conversations and pushing a country that Australia does have diplomatic relations, saying this actually is really important to Australia and we are going to raise it, as Rai said, at every opportunity. The other thing I'd say as well is that when a lot of these conversations are left to private diplomacy or closed-door discussions, there's no way to track and monitor them and monitor progress. So, as you would well appreciate, one of the key roles of civil society is to be watching this sort of progress. And I saw in the DFAT submission, it helpfully did set out the countries and where they have had engagement, but it was a yes/no sort of response in the table. And so, it could be raised in a side meeting or it could be raised at a really high level with benchmarks being set. And those are very different sort of approaches and very different, and you would expect very different outcomes from a situation where you're setting benchmarks to a situation where you're just mentioning it, oh, by the way, also, this is a problem. So I think that for the transparency is important because it holds everyone to account, including, obviously the government, that, if benchmarks are set and things like that, so that we can monitor it more closely.
You, in your evidence, you talked about the lack of consistency in terms of how Australia has approached the issue in regards to Vietnam and the public reporting of our views, and contrasted that with Singapore. Do you think that has weakened Australia's credentials in regards to its abolitionist position?
Yeah, look, I think it's important that Australia doesn't just speak up for human rights when it's convenient or when it's easy. I think, human rights is something that Australia has to take, as Rai said as well, a principled approach. And I think a principled approach means consistency. And that doesn't mean that, Australia, the government surely needs to attenuate its approach to each country, but based on its relationship and based on what it's seeing happening in terms of death penalty in each country. So we do appreciate that each approach should be different, but that doesn't mean that it doesn't have an underlying principle of being, no matter what, this is a standard that Australia expects and advocates on.
How would you characterise the level of awareness amongst Australians about the pattern of executions being conducted by Singapore, not just in recent time, but this is a significant pattern of behaviour? My view would be it's been poorly reported in Australia, and the Australian government has been very absent in drawing Australian attention to this and sort of advocating. Given our more trusted relationship with Singapore, I would argue that should give us a careful and considered platform to advocate against this, particularly when you think about the weakening of judicial standards around the process that leads to these executions. So my question is, how would you characterise the level of awareness amongst Australians about this? And do you think that if there was a heightened level of awareness amongst Australians, that might embolden Australia's advocacy?
I'm happy to go first, Daniela. I think the awareness around the use of the death penalty around the world among Australians is quite low. And I think, recent surveys have shown that, while, there is, good support in Australia for the abolition of the death penalty, that can't be presumed to exist without ongoing efforts around in relation to education. In regards to Singapore, I would note that, a couple of years ago we had an activist from Singapore visit our amnesty offices in Sydney and spoke in length to us about, as you mentioned, the sort of regression of the judicial system there and the impacts of that on civil society. That is certainly not well known in Australia. I think business interests have certainly been put to the forefront of that relationship. I think, and mentioned in other submissions to this inquiry as well, I think it would be useful for, in relation to travel advice, on the Smart Traveller website for Australia to list if a country retains the death penalty, and whether that is for the most serious crimes as permitted under international law, or for lesser offences such as drug offences in relation to Singapore. Part of this issue in terms of public education is, I think, and this comes to a broader point as well that Amnesty, maintains, is that advocacy around the death penalty cannot be just contained to when Australians are at risk of the death penalty. It's important to maintain that principled approach no matter who is facing the death penalty, whether they be Australian citizens or not. So it's almost like it takes an Australian citizen to be at risk of the death penalty for the Australian government to be vocal, for the Australian media to pay attention, for the Australian public to then become educated in those instances. So I think if the Australian government was more willing to take sort of a more outward, more principled approach, no matter the nationality, then I think that can carry through to the public as well.
Ms. Gavshen?
Yeah, and I would agree with that. I can't really speak to sort of the domestic awareness of the issue with respect to Singapore, but I certainly agree that I think when we also relegate these conversations to behind closed doors or to human rights dialogues and not actually do it in the regular as a matter of course, we sort of push human rights aside as if it's sort of this pesky issue that we deal with on the side, as opposed to being actually a central part of foreign policy and everyday life for everyone. And so I think that it's really important that the Australian government, when they are having these public dialogues with Singapore, and then have a public statement to be talking about it, because I think that also puts it into as you said, into the public consciousness of Australians that this is a big issue and a significant issue with Singapore, and one that the Australian government takes really seriously.
Can you identify any successful programs that you're aware of that have supported civil society groups abroad to advocate for abolition in retention estates?
I would have to take that on notice. All I would say is that part of Amnesty's recommendations to this inquiry included increased funding for civil society groups in retentionist countries, including options for them to apply for that funding with lots of notice, the ability to apply within their own language as well. But our international campaigner at Amnesty International would be more across those programs. I'm happy to take that on notice.
That would be appreciated.
And the only other thing I'd add to that is that, there are cases certainly with Singapore where there's been a track record of the opposite, of silencing and intimidating opponents and groups opposed to the death penalty. So we obviously see the negative effect that has.
You both have mentioned the existence of the oversight board inside the Australian Federal Police. Can you be more specific in terms of what improvements or additions to that existing function should be pursued in order to give higher level of confidence that the primacy of death penalty matters are properly considered, and what might be the best way to bring a level of transparency over the functioning of that committee?
Yeah, Amnesty's position is that the current process around that oversight committee, doesn't seem to be functioning well. I think you uncovered in Senate estimates yourself that it wasn't functioning. I think Amnesty holds the position that the existence of that process in of itself is problematic. This classification of low risk, medium risk, high risk, it gives the illusion that, there is somehow, a good sense of knowledge within the AFP of where these things are going to end up. The reality is we're talking about pre-arrest cases here, and we have no idea, in truth, where these things are going to end up. And, you know, a far more principled approach to this, as I've laid out in my introduction, was, you know, countries such as the UK, you know, they take a far more principled approach to this, and it's a lot more clearer in the sense that, you know, if there is a risk that the death penalty will be used in cases, cooperation will not be provided. We don't need these systems where we can assess if it's low, we can assess if it's medium, or if we assess if it's high. That gives the impression that, you know, this is okay at some level. It would be far simpler to say to countries that practice these types of, that practice the death penalty, to say you practice the death penalty in relation to crimes that don't meet international standards. It is as simple as that. We will not cooperate.
Ms. Jefferson?
Yeah, I mean, our position would be consistent with that as well. I mean, our general recommendation has been that there should be no police cooperation in cases where there is a risk that someone will face the death penalty. So that, for us, is very clear as well. In terms of that oversight board, if there is to be any oversight, for cases that may not include drug trafficking or sort of an earlier stage, but, you know, you kind of need to make an assessment. That should include a human rights specialist, because when you're looking at something from a policing lens and you're looking at it, that's the lens you're using and that's your framing. And so if you don't have someone coming in with a death penalty lens or a human rights, more broader human rights lens, you just simply are missing key points of the case. So I think that is crucial for any oversight board to have, is to be able to come in with a human rights lens.
So Human Rights Watch and Amnesty International would support a regular review mechanism of the operations of the Oversight Board done by a credible external party?
Yeah, absolutely.
And the widening of its membership to include agencies outside of the AFP or individuals outside of the AFP?
Yeah, I think
yes, and specifically legal and human rights.
Now, Mr. Newman, you're on the call. We can see you clearly.
Yeah, I can. They fixed up my problems inside my whole office. Now, I just wanted to come back to that point that I think that Danielle, you made. And am I right in believing that your position is that in relation to retention as countries, we should not engage in cooperation in terms of transnational crime, people smuggling, drug smuggling, in the circumstances where they have not abolished the death penalty? Is that your position?
Our position is that there should be no police cooperation where there's a risk that someone may face the death penalty. That's what we're saying. So if there's a risk that a person may face the death penalty, there shouldn't be police cooperation on that case.
Okay, on that case, but not broadly, generally.
Not broadly at all. No, not cancelling police cooperation, saying no police cooperation if there's a risk at all that it could lead to the death penalty.
Now, Human Rights Watch acknowledges Australia's engagement in multilateral advocacy. To what extent would you classify Australia's engagement as successful? Because you're critical of our bilateral engagement, which you say is missing in our approach and the advocacy. To what extent are we successful in the multilateral approach?
Yeah, I think Australia's doing a great job in the multilateral approach, and I think we raised that in our submission. I think at the Human Rights Council and at UNGA, in Australia, in the UPR processes for specific countries, I think Australia's done a great job in the multilateral arena. I think they led the statement recently with Costa Rica on it. That's great, but that's part of it. That's not the full range of sort of diplomatic tools available. And I think it's really important to be using multilateral fora and using it the way the Australian government are, using them the way the Australian government are. But we do strongly believe that bilateral is an important complement to that.
Now, in terms of countries that have moved, because not every country that has the death penalty is an authoritarian regime. Countries like Malaysia have moved from authoritarianism to a more democratic polity. for example, the Prime Minister administration led by Anwar Ibrahim in Malaysia is now doing things like establishing parliamentary committees for governmental oversight, engaging with the opposition in a way that giving them more resources. They have a question time. They have a very vibrant democratic system of government compared to what it once was. To what extent, when there's a change of government like that, is Australia taking the opportunity to then advocate in a more enthusiastic and determined way? And if so, what should we be doing? Because I know we're cooperating, for example, with Malaysia in that parliamentary reform, administrative reform and human rights reform. To what extent are we or should we take that opportunity in countries like Malaysia and elsewhere?
Two things to that, and Ryan, I don't know if you have any comments as well, but sort of, I think it's great. I think it's great when we see countries taking steps towards abolition, and I think it's really important that Australia supports those steps and does provide assistance where they can to move towards abolition. So that is certainly something we would encourage. The other thing that I think is useful is when Australia is able to use those examples with other countries in the region. So, for example, talking to Singapore about what we're seeing in Malaysia, talking to other countries and showing, using those as examples and using sort of the example of where Australia is willing to help and help progress towards abolition. But right, I don't know if you have
We, for example, provide parliament-to-parliament assistance and other assistance in this area to assist countries in the reform of, for example, establishing a public accounts and audit committee, establishing a proper committee system, establishing how entitlements and resources in oppositioning so that their systems of government, their parliamentary procedures are more democratic. We do this all the time, whether it's in South Pacific or Asia. To what extent have we done this when it comes to policy issues like the abolition of the death penalty? For example, there are politicians, Senator Dean Smith's a classic example, Graham Perrott, the member for Moore, Maria Van Vackeren, the member for Corwell, strong advocates for the abolition of death penalty through their political careers. To what extent have we taken that opportunity on that parliament-to-parliament approach to try and influence politicians or parliamentary systems abroad? And should we do that more?
Right, I don't know if you want to answer this question. I mean, for me, I think it's probably more a question for government to what extent we're doing it, but in terms of the Australian government's doing it. But from our perspective, it's to be welcomed. I think any work that works with other governments to work towards abolition should be encouraged. But to the extent to which it's being done, I think is a question for government, unless Rai has better answers.
Yeah, I think. I can't speak in depth to the bilateral relationships with countries like Malaysia, but I think as a general principle, that's obviously welcomed. I think it would be great if, when those opportunities are pursued, in terms of that cooperation, the death penalty is kept in mind, and there are benchmarks as well that can be reported on, so we can assess that sort of progress. So we're not just doing these things for the sake of doing them and things are regressing. It's good to have those benchmarks. In terms, just taking it back one step to the multilateral space as well, I think I would agree with Daniela in her assessment around Australia's contribution in that space. It really has been fantastic, and our international colleagues are regularly praising the Australian government's approach in those forums, particularly around the UNGA resolution in 2022. But that sort of approach needs to be maintained, and it's really important that it's maintained because there are continuing efforts to undermine progress at the UNGA with the death penalty moratorium, particularly from countries looking to pass wrecking amendments around sovereignty. The highest number of countries ever voted for that sovereignty amendment in 2022. So there has been regression in this space since about 2014. So it's really important for countries like Australia to maintain a strong principled opposition to amendments around sovereignty. That is a principled approach that Amnesty takes. Sovereignty is not required in that resolution. It exists already in the UN Charter, and specific reference to it only takes away from the impact of that biannual resolution. But beyond the UNGA, I'd really like to point out the importance of Australia taking this approach into other forums as well, particularly around the UN Commission on Narcotic Drugs. Amnesty's submission sort of goes into a little bit of depth around, having a more encompassing strategy around the abolition of the death penalty in relation to drug crimes. But unfortunately, bodies such as that at the UN, which are focused on drugs, have failed to incorporate, the principles of the UNGA moratorium resolution, and fail to even really recognise the use of the death penalty in relation to drug crimes. So it's really important that countries like Australia take the learnings from the UNGA, take the strategy, take the advocacy from the UNGA, and are prepared to take it into other forums where it's surely needed.
Now, my final question, Dean, and Chair, for the purpose, and it relates to something that Senator Dean Smith said before. And this committee, at its subcommittee level with the Foreign Affairs and Aid Subcommittee, examined how we can support civil society organisations to promote democracy and liberty and strengthen issues in the South Pacific fairly recently. And we found that there were real deficiencies in what we do as a country in this space. So I'm interested, and it picks up something that Dean Smith said before, the question about supporting those civil society organisations like trade unions, like women's groups, like advocacy groups, like individual journalism or professional journalist associations that can speak out on issues like this, human rights groups. So I'm interested, I know you're taking some things on note. What have we done in the past in this area, and what could we do in the future? I think it was the case that Amnesty International were going to get back to us about what we're doing currently. So if there's an historic knowledge that you've got, or what we should be doing in the future to improve the situation, can you please tell us?
Yeah, on the historical note of that question, again, I'll take that on notice. But moving into the future, beyond funding organisations on the ground in retentionist countries, making that funding and the access to that funding available in language in country, I think what Daniela pointed to, which is a really important point as well, is that Australia also needs to support individuals that often face state reprisals for their work in this space as well. Whether that be legal funding, whether that be, participating in court proceedings, ensuring that the Australian Embassy is, making their views known around, prosecutions in that respect, attending court hearings. These things all make a real difference, and I think they can be deployed far more effectively and more comprehensively into the future.
Yeah. Okay. Thanks very much, Dean.
Thanks very much, Mr. Newman. So on the same point, given the limited resources that are available to government and to DFAT in this particular area, should the emphasis be on funding organisations to make the general case of abolition to their communities, or should the funding be prioritised for what might be called technical assistance? So assistance that might support a better judicial process, assistance that might upskill legal professionals, Do you have a view about what would be the appropriate, where's the best bang for buck, so to speak, in terms of limited funding? So it would be good to do everything equally. That's probably not going to happen. But where should be the appropriate emphasis?
Yeah, look, I mean, I'm not really able to put a specific on where the best use of that funding can go, and as someone who's not responsible for the purse strings, I can quite easily say that they should be equally funded, and that there is a need in both areas as well. So I think that would be. And I think it would be an assessment based on each country as well. The assessment would have to be made, like what is the level of public support in that country for the death penalty? How much education and how much work in that space actually needs to happen? I think that is definitely the first step. And then you probably, depending on where that levels of support is, how much of that work has been done, you can start to look at that more technical assistance.
Ms. Gavson?
Yeah, I was going to say that second point that Roy made, I think it needs to be attenuated to the country. I think in certain countries where we know that the rule of law is so sort of fundamentally fraught, and there's no fair trials, and that there's obviously a different problem there around the system. And then in countries where you have better due process, but you've got a strong civil society that's trying to move towards abolition, obviously there's space there. There's less need there to be supporting the legal system and more need to be supporting civil society. So I think it does depend on the specific country.
Where a nation has demonstrated a spirit of abolition but not yet abolished the death penalty, to what extent should Australia be patient with their progress?
I'm happy to jump in, Ryan, first, if you want.
Yeah.
I think patience shouldn't be empty or endless, right? So I think that if there are clear benchmarks and those benchmarks are being met, I think the Australian government should be fully supportive of that. I think a country that's moving towards something in a sort of more vague, less sort of measurable way, and there's sort of no clear goals in sight, I think that's where I think it's sort of more important to be putting pressure on those countries to be setting benchmarks and working with them to actually get to the point of abolition. I don't think we should have just leave it to chance or leave it to sort of the political swingings within a country. I think it's something that should have very clear benchmarks.
Yeah,
Mr. Atkinson.
Would support what Daniela spoke to there around the benchmarks, and it goes to the point made previously as well in relation to cooperation with Malaysia, for example. Like, I think the importance of benchmarks and being able to measure that progress, I think really allows the Australian government to make those assessments on a case-by-case basis. But I think it also comes to the broader point about the need to grow the advocacy in terms of who is advocating around the world for abolition. It can't continue to be a handful of European countries, Australia and New Zealand. We need to look sort of outside of those reoccurring few. And I think if we can grow that movement, the conversations with those countries who, where you talk about maybe there's some progress, maybe there's a sort of level of patience that can be given. It's more than just countries like Australia that are having those conversations. It happens across the board.
Mm-hmm. You correctly identified yesterday as being the World Day Against the Death Penalty. Would it complement activities around the 10th of October if the Australian government was to use the 10th of October to make an annual statement that specifically identified its advocacy activities, success and perhaps not so successful, but also the statement publicly acknowledged those nations that continue with the death penalty and publicly acknowledged the number of annual executions.
Absolutely. Amnesty would support that. As long as it's an approach that is across the board as well. We have to be prepared to call out what we would consider our allies as well.
Yes.
The USA is one of the top 5 executioners in the world. We have to be prepared to call the USA out as much as we're prepared to call out other countries. So as long as it was inclusive of that, then absolutely Amnesty would support that.
Mm-hmm. And just from us, that was specifically one of our recommendations. Not the specific date, but one of the things that we did say is that we would like to see DFAT drafting an annual public report that does name the countries that retain the death penalty, provide regular updates on usage and cases and steps towards moratoriums or reducing execution. So I think something like that did culminate in, on October 10 would be a very, very useful sort of contribution by the Australian government.
Great. Well, thank you both very much for your participation and evidence today. And just to reiterate, progress is being made. You would agree with that statement in terms of the number of nations that are that are moving away from the use of the death penalty as a...
I would say absolutely progress is being made, but countries like Australia cannot become complacent.
And the existence of the whole of government strategy has been a useful tool for the Australian government, but also for organisations like your own?
Absolutely, but there's room for improvement.
Excellent. Thank you very much. Thank you for your time today. If you have been asked to provide any additional information, including questions on notice, we'd be appreciative if you could forward it to the Secretariat by Friday the 1st of November. Please note that responses to questions on notice will be published on the website and submissions, as will submissions to the inquiry. You'll be sent a copy of the transcript of your evidence to assist you with answering questions taken on notice today, and you'll have an opportunity to request corrections to transcription errors. Thank you both very, very much.
Thank you very much.
Thank you.
Just one second.
Is that your... Chris.
Ah, there's Chris. Oh. It's Mr. Hayes, yeah.
He just got off the bench.
Ah. Uh-huh. We'll proceed, Chair, if you're comfortable. I declare open this public hearing of the Human Rights Subcommittee of the Joint Standing Committee on... Oh, no, we've done that. Sorry, anyway. I now welcome witnesses from the Capital Punishment Justice Project to give evidence today. For the Hansard record... right, of course, my apologies. So I now welcome witnesses from the Capital Punishment Justice Project, but also representatives of the New South Wales Council of Civil Liberties and the Julian Wagner Memorial Fund and the World Coalition Against the Death Penalty. Thank you very much for your participation today. For the Hansard record, would you each please state your name and the capacity in which you appear before the committee today, beginning with the World Coalition Against the Death Penalty?
Who's about to log in?
Thank you. So, while we wait for that, we might invite the Capital Punishment Justice Project.
Sure. So my name is Elizabeth Wood. I'm the Chief Executive Officer of the Capital Punishment Justice Project.
Great, thank you. Welcome.
Thank you.
Today I'm appearing, my name's Sarah Covell, I'm appearing as Acting Director of Elios Justice at Monash University, but I am also Vice President of Capital Punishment Justice Project and on the Executive Committee of ADPAN, the Penalty Asia Network.
Great, well, thank you very much and welcome. Mr Hayes?
Yeah, Dean. Chris Hayes, I'm an ambassador for the Capital Punishment Justice Project.
Warm welcome and good to see you again. And Dr. Beebe, are you with us yet? Dr. Goldberg, or Mr. Goldberg, are you with us soon?
Here he is.
Here we are. Great, excellent. Mr. Goldberg, would you like to introduce yourself?
Yes, thanks so much to everyone for convening. Yes, my name's Matthew Goldberg. I'm currently the president of the World Coalition Against the Death Penalty, and amongst other things, a DPhil candidate at the University of Oxford, in which I'm assessing the UN resolutions on the death penalty and the questions of transparency and legitimacy and efficacy in that regard. And I'm also a board member of the Capital Punishment Justice Project.
And I understand also patron of the Julian Wagner Memorial Fund. Stephen. Oh, no, you're not. I'm coming to Mr. Kime now.
I can't formally count myself as that, but definitely support all the great work that the fund is doing.
Okay, Mr. Kime.
Yes, thank you. I had sorry, I just got a little bit of feedback here.
Yes, there is a bit of feedback, that's correct.
How's that? No, it's still there. I might just join again. Sorry, proceed with that.
We might come back to you once that's corrected.
Thank you.
Would anyone like to provide an opening statement to the committee? Ms Wood, thank you.
Sure.
Before we do that, Ms Wood, this is a hearing. This hearing is a legal proceeding of the Parliament. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. And I understand that Mr. Beebe has Dr. Beebe has just joined us.
Yes.
Excellent. Mr. Beebe, could you just introduce yourself and the capacity in which you appear?
I'm Martin Beebe. And it's Dr. Beebe. And I'm a committee member and executive member of the New South Wales Council for Civil Liberties.
Excellent. Thank you very much and welcome. Ms Wood, we'd like to begin with an opening statement.
Sure. So Capital Punishment Justice Project, or CPJP, is an Australian NGO that is solely dedicated to the universal abolition of the death penalty and other forms of state-sanctioned killing. On behalf of our partners with whom we made a joint submission, we thank the Human Rights Subcommittee for undertaking this inquiry and for inviting us to participate today. We noted in our joint submission, and we would like to repeat here, that Australia is internationally regarded for its strong position against the death penalty and its commitment to leadership on abolition. This remains critical, as while there is an encouraging global trend towards abolition, our region is home to the vast majority of executions every year, and many of our neighbouring states remain stubbornly committed to using the death penalty. We are greatly encouraged by the Australian government's principled abolitionist stance. At CPJP, we work closely across Asia with almost every significant group fighting the death penalty in their respective countries, some of which face strict government scrutiny and restrictions. The fact that CPJP can conduct our work from a safe space under an abolitionist government means we are increasingly being relied upon by our partners to both lead advocacy campaigns and to help ensure their safety due to the adverse government attention they receive for their work. Our joint submission reviews the Australian Government's progress against the recommendations of the previous inquiry and highlights opportunities for improvement to ensure Australia's consistency as an abolitionist nation and as a leader in global efforts to end capital punishment. We made 5 recommendations around 3 key outcomes in our joint submission. The first of these is to ensure that Australia's commitment to abolition is reflected in the actions of all levels of government, including in the rules that determine how they must act. Critically, we would like to see changes made to the legislation and guidance on government-to-government and police-to-police assistance to ensure that our laws clearly and consistently uphold our abolitionist stance. In the evidence given at the first public hearing, we were very heartened to hear that there is a clear whole-of-government commitment to Australia's position on the death penalty, and that this informs how authorities such as the Australian Federal Police act and make decisions. Yet under the current legislation and the AFP national guidelines on police-to-police assistance in death penalty situations, we believe that there is too great a risk that actions by Australian authorities in their efforts to assist international counterparts can put people at risk of facing the death penalty. The second key outcome is to improve the assistance provided to Australians exposed to the risk of the death penalty in foreign jurisdictions. From our experience, decisions made in the very early stages, particularly around legal representation, can be critical, but people need help navigating this. We know that the Department of Foreign Affairs and Trade has a huge regard for civil society organisations and could make better use of such CSOs, such as CPJP and our network of partners in retentionist countries, to provide advice and guidance in such circumstances. And the third outcome is around providing a significant boost to the amount of dedicated, ongoing funding that is available for activities aimed at the abolition of the death penalty. Ultimately, what's coming through strongly in the submissions to this inquiry and in the evidence so far in the public hearings is that the Australian Government should rightly be proud of its principled position on the abolition of the death penalty and the role it plays in multilateral advocacy in particular. What is also coming through strongly is the need for all of our actions to be consistent with this principled approach. I'll hand over to Sarah.
Thank you.
Thanks very much. I'm Shane, the Federal Member for Blair and Chair of the overall Joint Standing Committee on Foreign Affairs, Defence and Aid. So I'll take over from now. Just if there's anyone else who'd like to make an opening statement, that would be good.
Yes, please.
Mr. Klein, it's glad to see you, Stephen, back on deck. Have you fixed up the ICT problems? You're on mute. You're on mute, mate. On mute. You're on mute, Stephen.
I had joined the committee twice.
Okay, yeah, okay.
We were hearing everything twice.
That was the problem. Would anyone else like to make an opening statement? Stephen, Chris, Matthew, or anyone else?
Yes, please.
Yes, please.
Okay, great. If someone else would like to make an opening statement, please feel free.
Okay, I will. My name's Sarah Koval. I'm the Acting Director of Elios Justice and, as I said before, also on the board of CPJP and of ADPAN, the Anti-Death Penalty Asia Network, which represents activists across 20 countries in Asia, all focused on abolition of the death penalty. Australia's strategy for abolition of the death penalty is strong and firm, which makes us an absolute leader in the global abolition movement. CPJP has been very focused on the implementation of our strategy. Thanks to the support of the Australian Government, in 2018, CPJP and Monash University's law faculty established Elios Justice. Our research, led by Dr. Mai Sato, has examined how the death penalty for adultery, same-sex sexual acts and blasphemy is an affront to the right to life. Our law students work with partners on capital defence work and advocacy across our region, ensuring that we advocate for all people on death row, not just Australian citizens. The Australia-Pacific region has the highest number of countries that retain the death penalty in the world, which means that even if these countries are not actively executing, there are thousands of people living on death row in death row conditions that often breach the UN Mandela rules, such as ongoing solitary confinement for years. In all the countries that retain the death penalty, we see a lack of access to lawyers, significant deficiencies in fair trial rights, and an overrepresentation of persons from poor and vulnerable communities on death row. This is why Australia cannot look away. The use of the death penalty in the Asia-Pacific region for drug offences is often situated in war on drugs rhetoric, a policy that is both ineffective but, more importantly, has been one of the most harmful, punitive drug control responses we've seen. Drug offences clearly fall well outside the most serious crime ICCPR definition. Focusing on removing the death penalty for drug offences will significantly limit the scope and use of the death penalty in our region. Just last week, as you've heard this morning, we saw the government of Singapore execute Mohammed Azwan for the possession of 26.5 grams of heroin. Last year, a person was executed for engaging in a conspiracy to traffic a kilo of cannabis in Singapore. Like all 20 people executed by Singapore since early 2022, Azwan was hardly a drug kingpin. Last Thursday, he appeared on his own before the Court of Appeal in Singapore begging for a stay of execution. He was unable to get a lawyer to represent him on the ground. Whilst his clemency application and criminal appeals had been exhausted, he was part of an ongoing pending civil case that challenged the very laws that govern the post-appeal proceedings for people on death row. He was nevertheless executed last Friday. Human rights defenders and civil society organisations on the ground in Singapore who have critiqued Singapore's practices on the death penalty have been met with harassment, including by the Law Minister naming civil society organisations and individuals challenging the death penalty in Parliament, including reading out the email address of an activist in Parliament and issuing oppressive corrections notices under legislation purported to address online falsehoods and manipulations. Yesterday, ADPAN, a regional network of anti-death penalty activists not based in Singapore, was served with a corrections notice by the Government of Singapore. As an example, I think, of this harassment that goes beyond the borders of Singapore. A pleasing point of contrast is the Government of Malaysia's abolition of the mandatory death penalty in 2023. Through ADPAN, we had the opportunity to engage with lawmakers in Malaysia in the lead up to this important step. The Federal Court is now resentencing over 1,000 people, now with the ability to apply discretion in sentencing. The clear trend is that people who were convicted of drug offences are moving off death row. In Malaysia, where 95% of women were on death row for drug offences, the expected outcome is that there'll be very few women remaining on death row at the end of this process. This contrast is important as it demonstrates that with an ongoing engagement, previously entrenched positions can change, and we should think of this when thinking about governments like Singapore. Finally, as someone who's worked on a number of cases of Australian citizens charged with capital offences, I want to emphasise the need for specialised capital defence lawyers to be engaged at an early stage so as to avoid a conviction at trial. Supporting CPJP to assist local lawyers with accurate and effective evidence, gathering relevant information in Australia and engaging expert evidence can make all the difference, as Luke Cook, an Australian citizen that we worked with who was exonerated by the Supreme Court of Thailand in 2021, will attest to. Thank you.
Thank you very much. Martin or Matthew or Stephen or Chris, anyone like to make a statement as well?
Could I
Thank you.
I'll get Chris first. He's the first person who said something.
Thanks, Shane. Obviously, it's no surprise to you all members of your committee that I've stayed involved in the issues surrounding the death penalty. But look, as Elizabeth and Sarah said, we're proud to hold a very strong, bipartisan supported position on the death penalty in our country. As you and your committee know, members and senators, when we travel overseas and we visit jurisdictions that do have the death penalty, members are encouraged to speak about Australia's policy, and it's got to be encouraged. We've got to do it at all levels of government, but particularly through our leaders, our members and senators. And you recall that when Julie Bishop was, as Foreign Minister, was elected onto the Human Rights Committee of the UN, one of her key principal positions that she took, supported by both sides, was Australia's position in support of the universal abolition of the death penalty. I'd like to just pick up on where Sarah left off about the Luke Cook case, and you might recall, Shane, we had a number of petitions associated through that, through members of Parliament at the time, but there's no doubt in my mind that foreign affairs can be complicated. But in the Luke Cook case, he's an Australian citizen, arrested, charged, convicted in drug-related crimes, sentenced to death, appealed, the Court of Appeal in Thailand upheld the conviction and also the sentence. Seemingly no further legal opportunities available to this man. It was the Capital Punishment Justice Project through Stephen, Sarah and Elizabeth, through their extensive network of lawyers in this country and abroad, that proposed the development of an amicus brief, acting as friends of the court. Now, regrettably, it was opposed by the minister at the time, as well as the government. They declined to support an amicus brief being sent to Thailand. By the way, and it's probably good that Senator Smith's not sitting there at the moment, because we did send an amicus brief. It was actually co-signed by Senator Dean Smith and myself. It went to the Thai Supreme Court. It was accepted by the court. The consequences were that the court decided to conduct the review. They found serious discrepancies in the original investigation, which would have resulted in the miscarriage of justice. The prosecution withdrew all charges against Mr Cook. Bear in mind, this bloke's on death row. No longer on death row. He now lives in West Australia, comfortably with his family. Now, this shows you that things can go wrong. The minister at the time arranged for me to have a briefing from the Federal Police Commissioner, as well as his head of Australia's AFP in country in the mission. They were at that stage satisfied with the investigation conducted by the Australian Federal Police. By the Thai Police. But it does show that things can go wrong. And if it wasn't for this amicus brief, Mr Cook possibly would have, this stage, would have been deceased. So look, I've been in politics long enough to know that governments can, feel elements of diplomatic discomforts when dealing with friendly jurisdictions. What the CPJP has done is, I suppose, it's lent substance to Australia's policy on the death penalty in a very, very practical way on this occasion. With recurrent funding, we could continue to do that, not simply case by case, but actually in partnership with other actors through multiple jurisdictions, both in country and external. We can advance Australia's policy against the universal application of the death penalty. And just one further thing, and again, still focusing on the Luke Cook case, Sarah did talk about being able to access lawyers overseas and help coordinate defences. In Mr Cook's case, he was in prison. A bloke, someone who purported to be a lawyer, walked around the prison and offered to represent him. He was the only one who spoke English. So he got signed up as the lawyer. The Australian government was paying this person as a lawyer, who was an American, but he was sourcing out the defence to in-country lawyers. It turned out this fellow who purported to be a lawyer was never a lawyer in the first place. And what's worse, not only was he acting for Luke Cook on the death row, he was actually acting for the principal prosecution's witness against him. So, and his bill was being paid by the Australian government. So this is where the CPJP can do a lot in terms of looking at competent defence in foreign jurisdictions as well. But I'll leave it at that, Shane.
Yeah, thanks, Chris. On that note, I might go to Stephen, and then I'll go to Matthew, then Martin. Stephen.
Thanks, Shane. I just wanted to formally record that I'm appearing today on behalf of the two Brisbane-based organisations, Australians Against Capital Punishment and Julian Wagner Memorial Fund, and those organisations are signatories of the CPJP submission as well, and so I obviously join in endorsing the remarks of Chris and Sarah and Elizabeth and Matthew in due course, and I do so as chair of Capital Punishment Justice Project as well. I didn't want to add anything to what has been said, just to join the support in those various roles to what has been said. Thank you.
Thanks. Matthew?
And thanks, everyone. I'll follow Stephen's lead and be relatively succinct, but certainly here to reinforce and support the submissions that Sarah and Elizabeth are presenting so ably. And maybe just at the outset, I should recognise, and perhaps this has been a matter of discussion in some of the earlier work of the committee today, but I'm joining from New York. I'm here for the resolution calling for a moratorium on the death penalty in the General Assembly, and so it's still the 10th of October over here, and that means that at least I'm still in position to recognise that it's the World Day Against the Death Penalty, which is the work of the World Coalition, of which CPJP is a very active and trusted member. And I represent CPJP in my role on the board there. And the World Day Against the Death Penalty, as I might be reiterating for those who've already explored it, unifies the global abolitionist movement, or at least that's the purpose of and function of the day, to mobilise civil society, political leaders, lawyers, and all those in the public sphere to support the call for universal abolition of capital punishment. And so it really constitutes an opportunity to consolidate the great political and legal and cultural work that all of the abolitionist community do year round in raising awareness and pursuing the big objective which constitutes abolition globally. So I don't imagine that it's just a quirk of the calendar that World Day is upon us, but felt necessary to acknowledge it here. So thanks so much for everyone, particularly the committee, in giving some careful consideration and an important time to explore what next we can do to advance this issue.
Thanks, Matthew. Martin, over to you.
Thank you. There's a contradiction when Australia advocates the end of the death penalty, but the Australian Federal Police remain able to pass on information which contains, to countries which have the death penalty, information that leads to people being put to death. You'll remember the Bali Nine, 2 of whom were in fact put to death, but you may not remember that 2 of the top officials of the Australian Federal Police declared at the time that in similar circumstances they would do exactly the same thing. We seek changes then to the laws and police instructions in relation to the Federal Police, where they're giving information to countries that have the death penalty. They should not be able to give such information unless they have assurances from the appropriate authorities that the death penalty will not be carried out. The Extradition Act provides a good model of such a restriction. In our view, the Australian Federal Police Act, the Mutual Assistance in Criminal Matters Act, and the Australian Federal Police National Guidelines on International Police-to-Police Assistance in death penalty situations should all be amended with similar provisions to those that are in the Extradition Act. In our view, it's also vital that information arising from the cracking of encrypted communications is not passed on to death penalty countries without guarantees that the death penalty will not be carried out. And that includes information about how to crack the codes, such as that involved in Operation Kraken or in the ANOM sting. Thank you.
Thanks very much. Can I ask a number of questions now? Something that came up in the earlier session was, and I think it's been articulated in the New South Wales Council for Civil Liberties, is the concept of a new DFAT public strategy document. And certainly that was alluded to by Amnesty International as well as Human Rights Watch Australia. That is, we have a new strategy in that area from a DFAT and governmental level. So I'm interested in exploring that. I think it's Martin, it's you at the Civil Liberties Council of New South Wales that specifically says it like that. So I might ask you that first question. What would that new DFAT public strategy document look like?
I'm afraid I'll need to take that on notice.
Okay, all right. And I asked a question earlier. Can anyone else like to comment on that? Because I know that came out from the New South Wales Council of Civil Liberties, but there are a number of organisations who have so far alluded to something like that, a new DFAT public strategy document. What would it look like? Anyone else like to comment on that?
So CPJP has advocated on this previously, and our view is that the previous version explicitly excludes mutual assistance and police-to-police assistance. And while we are also advocating for changes to the legislation, we really do think that the strategy should not exclude those, given that that is really where Australia sort of falls down in its sort of principled approach, or runs the greatest risk of doing so, where they have the potential to share information in death penalty cases, and the strategy doesn't actually say you must adhere to the strategy in this situation. I don't know if Sarah wanted to add.
Sarah?
I wholeheartedly agree. This is, I think, the crux of the matter, and our recommendation 1 and 2 really go into this in great detail as to what proposed legislative amendments we would strongly recommend, and that we can have a great principle, but we are seeing gaps, and it's really disappointing that this far past the Bali 9 case where we still have these gaps in place.
Now, we've got a new strategy when it comes to foreign aid and assistance. We've announced that in the last year or so. But I want to know how we can balance our international obligations in providing assistance and cooperation with countries, and at the same time advocating strongly for the abolition of capital punishment in their countries. Can anyone like to comment on that balancing act and how difficult that is and how we can go forward in a better way?
Well, Shane, can I just make a comment on that? Clearly, given my background, I support the exchange of criminal intelligence information. But part of it's got to be on the basis that our law enforcement agencies are playing their role in our whole of government approach in terms of the universal position against the death penalty. Where we see it as an absolute benefit to be able to share information, we should be leaning on those jurisdictions to understand Australia's position. We need to actually use the issue of criminal intelligence exchange as part of our advocacy for the universal abolition of the death penalty. And like members of parliament, like our bureaucracy, the police should be also playing a role in that, in their level of cooperation with foreign jurisdictions.
Because the evidence we had earlier today was, in fact, that whilst we should continue to cooperate with transnational crime and people smuggling and international drug efforts, where that impacts on the prospect of the death penalty being there, we should cease to do so. What's your views in relation to that? Anyone like to comment?
Well, if I could comment, it's not that we should stop cooperating with them, but we should make it a condition of our cooperation that they guarantee that no death penalty will be carried out. So if you look at the Extradition Act, you'll see a very straightforward clause section within that, which makes exactly that sort of restriction.
Okay. Can I ask this question now? I think, Sarah, you were talking about the specialised capital defence lawyers. To what extent should we be providing that assistance, and how can we do it better if we are to do so? Should there be a fund in this space to assist Australians? Should there be a fund to assist other nationals? How can we do that better?
Thank you. The Australian government does support Australians who are facing capital offence charges, and that is extremely appreciated. I guess drawing on the points that Chris Hayes raised, the idea is making sure that the lawyers engaged are lawyers who, at best have capital defence experience, but at least...
Not if they have the right to practice.
Yeah, the right to practice. I think that when Australians are in a foreign jurisdiction where they might not have the language, the first instinct they might have when given a list of lawyers is to see who speaks English. That is not enough of a criteria to be a experienced capital defence lawyer. It has to be beyond the language skills, and it has to be people who've got criminal law, at least criminal law experience, let alone particular experience in these cases. And that's kind of where, from a CPJP perspective, we're saying use us. We have, through myself, who's on the board of ADPAN, and through Matthew Goldberg, who's on the World Coalition Against the Death Penalty, we've got very good networks. It's important that people be engaged who are actively working in this space. I guess there's a role that civil society organisations can play that government can't, in terms of working on the ground with other civil society organisations and making sure that we are appropriately providing information, background information on the person's life in Melbourne or whatever state they're from, access to medical records, access to mitigation evidence that can really feed into how the case is run. The ultimate aim is to stop it going beyond trial. That if early assistance and meaningful assistance can be given, avoiding a conviction really actually is both a better outcome, of course, but also a much less costly outcome financially too.
Now, I might ask this question to Stephen. Is there a role for law societies or bar associations in this area in Australia to cooperate, assist, provide counsel and training and help for lawyers who may not necessarily specialise in capital defence in other countries? And to what extent are we doing that at the moment?
Yes, there is. There's both, I think, a willingness on the part of organisations like the Law Council, and the Law Council has made a submission to this committee. There's organisations like the International Bar Association Human Rights Institute, which also actively campaigns against the death penalty. There's also organisations like Law Asia, through which local Australian law societies and law councils can work as well. The CPJP itself has worked in a number of countries, including India, in providing educational materials for not only defence lawyers but various participants in the system, including judges and prosecutors. So there is a lot of work being done. Nick Cowdery, the former public prosecutor in New South Wales, he gets called upon a lot to give lectures to prosecutors in a lot of countries, not necessarily on the death penalty, not just on the death penalty, but with regard to concepts such as the rule of law and prosecution conduct. So there's already some things going on. There's a willingness with lawyers' organisations in Australia and overseas, and I think it's something that would I think, enjoy a particular investigation to see what more can be done and what opportunities can be taken up. Sarah and Elizabeth probably know more about those courses that we've been involved in providing. Thanks.
Thanks. Sarah Elizabeth, can you care to comment on that concept that I've just put forward and Stephen's affirmed, that is cooperation from our lawyers at various levels in states and territories, based on the experience of people like Nick Cowdery, giving advice and assistance in other countries where they are retentionist. Can you comment on that?
Yeah. Absolutely. We, CPJP, work very closely with a number of pro bono lawyers who assist with strategic case research that we share with various partners around that we work with. Of course, I'm not going to go into detail as to whom, but that model is certainly demonstrates the strong passion of we've got volunteer lawyers in a number of states who are very committed to this work. But on top of that, there's some incredible international bar associations and organisations like the Malaysian Bar. Like one of the reasons why there's been so much success in Malaysia on the ground is the strong activist position of the Malaysian Bar. And I think kind of engagement between bar associations is a really effective way. Particularly when critique of the systems is very much focused on their fair trial procedures. I think people who can call out other common law systems are well placed to do so. So I think lawyer to lawyer and judge to judge exchanges is a very important emphasis.
Now I pick that last point up and say, in the last 12 months, I led a parliamentary delegation at the request of the Foreign Minister to Malaysia. While I was in Malaysia, meeting with politicians and ministers and civil society groups and lawyers and the like, I discovered that they were getting some advice, and one of our distinguished former politicians in Australia, a certain chief whip, was actually giving them advice, Chris Hayes. So my question is to you, Chris, and I asked this earlier, with the parliament to parliament, the politician to politician engagement. It's not just the legal societies and law councils, etc., but you've had a role, and they told me you were giving some advice on parliamentary committees and parliamentary procedures and the like to the Malaysian politicians in Parliament. So I'm interested in your role there, but also how politicians can play that role as well, in former politicians.
Well, Shane, I'm glad I didn't do it all in confidence then. Look, I think it is important that once we have a position we take in this country universally against the universal application of the death penalty, it can't be something that just exists on the books. We've all got to be committed to it. As you know, as a Member of Parliament, when you go overseas, we do encourage our members, when you visit a foreign jurisdiction that has the death penalty, don't be reluctant to raise Australia's position. And it's something that we should be proud of and not hide behind. And that's what I'm a bit worried about, that Luke Cook's case, where I think we went soft on that for probably diplomatic reasons, because it's a friendly jurisdiction, whereas the CPJP could get out and really give some substance to Australia's position. But in terms of countries like that where they seek advice, and by the way, I know one of my trips to Malaysia, Dean Smith was with me, and this follows on to what Sarah was saying a little earlier about foreign jurisdictions. The legal fraternity is doing well, but where poor people cannot afford a lawyer, a paid lawyer, don't do that, Rose. My dog's just nibbling with my feet. But where they can't, some of these jurisdictions do have legal aid, as you expect. But legal aid, we were told from various countries, is so paltry. Lawyers are under pressure to encourage their clients to plead guilty, and we will make applications for clemency. And as a consequence, you'll see that most of those people on death row then are poor or coming from very disadvantaged backgrounds, because it was put to us by a number of lawyers over there, if you can afford a competent lawyer, you will not be on death row. So, look, I just think from a position as comfortable we have in this country, it's not just the members of parliament, but we should be encouraging all our actors, whether they be bureaucrats and indeed our federal police that are positioned in a lot of these missions in other countries, be also putting forward Australia's universal position.
Thank you. Well, thanks very much. Now, I might ask Matthew or Martin about this, and I mentioned it too earlier, about working with civil society and non-government organisations. What are we doing, and how can we do it better, and what should we do in the future?
Again, I need to take it on notice.
Okay. Matthew, any thoughts?
Yeah, thanks, Shane. I'll jump into the fray. Yeah, I think, look, as is evidenced from this sitting alone, the function of civil society organisations and on this issue is quite or can be quite immediate and profound, and I think that's because the civil society organisations like CPJP bring a certain level of subject matter expertise that positions them really well to provide assistance and advice, at a number of levels, and so that has application to precisely the sort of conversations and opportunities that Chris was referring to in the political sphere. It's certainly the case that NGOs in the field with experience of the question of the death penalty in a number of retentionist jurisdictions make it their mission to provide up-to-date advice and instruction to those that might be in a position to advance the issue at the highest levels, and that's I think certainly a major facet of the projects of Australian groups like CPJP and others, and really all of the membership, the vast membership of the World Coalition. But it's not just preparation of materials and advice to Parliament. I think it's a kind of cross-cutting approach and a cross-jurisdictional one that's really proactively illustrated by CSOs in this space. So we see civil society representatives working across all of the mechanisms of the United Nations to advance the issue of the death penalty and call for universal abolition, and to achieve this point at which at law there may be realised a prohibition of such a penalty. And we see it also in the legal space with a great significant deal of cooperation between those in civil society and those who come from the legal profession, and of course there's a mixing of worlds in furtherance of the big issue here. So I think if anything, if I could just really underscore and emphasise that the civil society actors on this matter play such a major role, and they do so also in a manner that is often ill-resourced and in conditions and circumstances that are sensitive and challenging. And I think that that more often than not, they're treading this territory in a way that is really quite sophisticated and it's self-evidently in the national interest. So I think that's a yes to the question about the importance of the CSOs in
Can I say this? One of the things that I found as a politician is you get many meetings requests, And you've got many organisations that you wouldn't necessarily think would have positions on various issues. For example, the BCA would have positions on everything from climate change to industrial relations. The trade union movement would have positions on everything from nuclear power to industrial relations. You've got faith-based organisations that have a variety of different positions they take. Are we identifying, not I'll call the usual suspects, but other organisations in these countries that may be our willing allies?
Yes.
As organisations like business and commerce and faith-based organisations and women's groups and media opportunities, journalists, are we engaging with them as well? And to what extent can we do it better?
Can I?
Sarah, you go here.
Thank you. The point you raise is really, and also kind of feeding off what Matthew was saying, is really critical. So, for example, Elios led a report on rape and death penalty in South Asia. And looking into that, one of our key recommendations of what we really noticed had worked effectively in trying to challenge the use and expansion of capital offences for rape and other sexual assaults was having CSOs work together from different areas. So the kind of intersection between capital defence lawyers, but also gender rights advocates and child rights advocates who are not necessarily going to... the Venn diagram intersects in one area where it was all agreed that the death penalty was not an appropriate punishment for different reasons. Not that everyone involved agreed it was against the death penalty, but working on the common areas meant that it was more effective to work together on that overlap. Similarly, on the ground in Malaysia, what's been really effective is the anti-death penalty activists also working with disability rights activists and also working with drug policy, and that's been really effective too. So, so strategically funding interactions where it's drawing in from the kind of overlap of vulnerabilities is really important in order to get a more substantial response.
Yeah. Can I ask also questions about what opportunities you have? We mentioned Malaysia before, a country that's come out of an authoritarian period of time and now is a lot more democratic in the way it handles things. What opportunities are there globally to improve their situation and increase abolitionist countries in number?
Matthew Goldberg, this is right up your alley.
Matthew looks like he's the guy.
I don't know. I was taking a run up, but I didn't know whether I'd be.
No, I can see you. I can see you're keen. Go on, Matthew.
No, I mean others will dive in, but I think the opportunity to really advance and further disseminate this position of abolition globally is it's really interestingly poised. Where one kind of frame of reference for that can be the moratorium process that we're engaged in at the moment. So if we're looking at what constitutes maybe a reflection of the trend towards eradication of the death penalty, then it's helpful to recognise that we're seeking to reach the threshold of 2/3 of UN member states might vote yes in support of the call for a global moratorium, which is not insubstantial, but I think beyond that, we should really be proceeding on the basis that it is feasible to reach a stage in the foreseeable future at which there is a norm that is capably recognised for the prohibition of the death penalty. And there are a couple of different ways in which that might arise. There might be a specific new norm for prohibition of capital punishment, or we might come to understand that the prohibition against torture has a broader application now, that we can move to this point at which we acknowledge that that the death penalty itself is tortuously imposed, and that it's implausible to unravel it from the protection that we expect arises for people from torture. So, what does that mean for actual opportunities to do that in practice around the world? They're really many and varied. I think that much the focus here necessarily is I imagine in Southeast Asia, given or in Asia, the work of CPJP and the regional interests of the committee, and so beyond simply in Malaysia, we're looking to states like Thailand to move nearer to an abolitionist stance. Even in Indonesia, I know that many of us here have been involved quite intimately in death penalty proceedings there, but there's been quite some time past now without executions, and we should recognise that that's indicative, perhaps, of an acknowledgement of the opportunity for a changed position. But reaching more broadly, the coalition's engaged at the moment in a campaign for the introduction of a protocol against the death penalty in the African Commission, and there are a number of African states that we're looking to now to further embrace the trend in Africa towards an abolitionist stance. Substantially. So, that might be states in the General Assembly here, like Zambia or even Zimbabwe, for instance, who might be moved to support the call for an international moratorium because that will come to best reflect the conditions within their own jurisdiction and their expectations for the abolition of the death penalty in that region. So there's a number of opportunities for abolitionists to reach a point of relative success, and I think the work of the Australian government and Australian civil society actors and the legal profession and other supporters is really significant in that context, because Australia as a party to the second optional protocol has been really demonstratively proactive in pursuing the objective that we have for international abolition, and I don't think that it's feasible to reach that point and to play a facilitative role in realising these kind of legal reforms internationally and domestically without countries that have ratified the second optional protocol stepping up to the plate to embrace the opportunity that arises in the international community. So, others will have a view about where in particular, but there's a trend to pursue.
Thanks, Stephen. You wanted to say anything?
Yeah, I just wanted to bring 4 points together with regard to a couple of your recent questions, Shane. I think the first one I mentioned, research is really important. Sarah's mentioned a couple of things we've done recently, but a really good example of what can be achieved through research is that Professor Sato, I think in about 2014, 2015, did research into the state of public opinion behind the headlines in Japan, and showed that people only supported the death penalty basically because the government supported the death penalty and they actually weren't opposed to it. So the government didn't have to be afraid in Japan of abolishing it, which is quite detailed research but quite important. That was sufficient to convince the Bar Association in Japan to actually take up a position opposing the death penalty. So research is really important, and it's not research that you might just think of yourself straight away. I wanted to talk about funding. Government departments, not through desire but through necessity, tend to fund on the basis of projects. What can be done in this area, such as continuing to build up intelligence on which defence lawyers in Ho Chi Minh City are genuine and which ones are completely hopeless and just want to rip your money off is not something that can be wrapped into a project. So particularly with regard to CPJP, but I think with regard to other organisations in this space, there's a real need for recurrent funding. I spend most of my time at night sending emails to people asking them to give me $500 so that we can keep operating for another 12 months. There is a real benefit for the government in terms of this policy to fund CPJP and probably other organisations on a recurrent basis in a sufficient way, not do this report on this subject that we've just thought of and we'll give you $20,000. The third thing I wanted to say is, in terms of developing the strategy, I think one thing that DFAT could do is to employ Chris to actually write a manual on the way in which members of parliament, ministers, judges, lawyers, law associations can actually do advocacy when they happen to be in a country overseas. I think we say all the time in documents like the strategy, everybody should be involved in pushing this forward. But I think a how-to document that goes for 5 or 6 pages on all the opportunities you can use would be really useful. And the fourth point I wanted to make is the strategy is a whole-of-government strategy. That's what it's intended to be. But I think by excluding the Commonwealth Police stuff from it, apart from that it has regrettable results in itself, it makes it a DFAT strategy. And it has to be a whole-of-government policy. It should not be able to be categorised as just something that belongs to DFAT, that defence has got nothing to do with, that policing's got nothing to do with. So I think it's really important that even though DFAT is probably the department best to review it and develop it and add to it, it needs to be somehow embedded so it doesn't get, it's not just what 3 people on the human rights desk get to do when they don't have any other jobs. It really, really does need to be a whole-of-government policy and accepted through the whole of government as a whole-of-government policy, not just something in a corner somewhere that somebody on one desk looks after.
Thanks, Stephen. Anyone else like to comment on Stephen's very good point, 4 points, valid points there?
Sorry, Shane, can I ask a follow-up?
Yeah. Yes, please.
Sorry, and I apologise, I've come from somewhere else and missed the beginning. But just in relation to your last point around the whole-of-government strategy, I mean, we heard from DFAT and the police at an earlier hearing, and, they talked about how they do work together. I wondered if you could... You have outlined, a bit more detail about how you think that could work, but perhaps maybe flesh that out a bit more from your perspective, and also maybe, Chris Hayes, given your background, whether you had any further commentary about how that could work. Because, I think it's easy to say these things, but it's actually quite complex and there's such big beasts and bureaucracies that it'd be handy to understand and unpack that a bit more.
You go first, Chris.
Thank you, Senator. Look, it's just a matter of being somewhat committed to it. Look, I'm not sure you're aware of my background, but yes. I've certainly had a lot to do with the police for many, many years, and I see the value of criminal intelligence exchange. But there's got to be limits to it. By the way, what I've saw in my 18 years in the Parliament, I've saw certainly changes in behaviour in, say, like a country in Vietnam, for instance, that still is retentionist. But if an Australian citizen is charged with and convicted convicted and sentenced to death, the view that seems to be taken, it seems to be informal, but it's one that's taken probably because of our position, that they've recognised our position. Australians are not. They're not executed in Vietnam, and that appears to be the case for other countries that hold an abolitionist position. And it's because we have diplomats, we have visiting members of Parliament, for all that time going over to countries like that, explaining our position. Like when, as you know, Senator, when we'll have international visitors come and visit Parliament in Canberra, that they'll want to talk about their cultures and things of that nature. Well, this is almost a cultural thing to us. We shouldn't be afraid to actually say what we stand for when it comes to something like that. And countries want to build a positive relationship with us. Malaysia is one of those key examples of this. That used to be, well, it still is, retentions at this stage, but it's changing. And their position, has largely been influenced by others. Like in Malaysia, for instance, and going over there, which I do occasionally, they actually, even in their parliament, they review our standard operating procedures of our parliament. That's why they take the Speaker and the President goes over there occasionally, talks about the way we operate within our parliament. People look to see where there's advantages in moving forward. Now, I'm just saying that members of Parliament should be skilled up that when we go over there, we should be talking about those things and not be hiding behind it. Look, we had a lot of people visit the Philippines over the last number of years, notwithstanding the fact there was 27 extrajudicial executions. And I've got to say, I didn't see too many people raising that when they were in country in the Philippines. But you just got to have the courage of the conviction to stand up for policies that we hold dear. And that goes not only for members of Parliament and senators, it's the bureaucracy, and it is our federal police that have an interest in criminal challenging exchange. They should be saying where our impediments for not being able to do these things and encourage other countries to move forward with us. And where countries do make changes, let's not just tick those off. Let's go and celebrate it. Let's go and make sure that they understand that they have our support. Look, I just think that there's more that we can be doing as a progressive nation in that regard. And in terms of your committee, we used to invite, this is going back some time when I was there, but we used to invite ambassadors and from other countries and high commissioners in Australia to come and address your committee. And by the way, the very first country we got to come, the ambassador was from the United States, because we thought we don't want to start from countries that would, we as Australia will want to educate you. We want to encourage people to move down that path in somewhat partnership with us. And one of the big executors was the United States. So well, there again, I don't think we ever got to talk to the Chinese ambassador. But look, I just think we've just got to be progressive the way we're going about and doing this in all levels, and certainly empowering organisations like the Capital Punishment Justice Project with their extraordinary network within international legal fraternities. They can do that on our behalf without compromising us or defat what they might see as their own diplomatic interests.
Thanks, Chris. That precedent still happens. We still speak to high commissioners and ambassadors regularly on issues.
I'm glad there's some leadership there.
That's right. Lisa, any more questions?
No, that's good. Thank you.
If it's okay, I just wanted to add too on the...
Yes, and please go ahead.
So I guess sort of circling back to one of the things I flagged at the start and that we are hearing through a lot of the submissions and the public hearings is that it is about consistency, that if Australia, we have a good reputation internationally, a really good reputation as an abolitionist nation, but that does need to be reflected across the whole of government because, again, we've sort of led a lot of things in the UN mechanisms, the UPR, the moratorium, and those are the situations where I wouldn't say it's easy, but it is easier to lead in that space because there's a lot of the human rights mechanisms. Of course, they're going to be quite supportive of the right to life. But it needs to also be in the more difficult situations where maybe Australia has a little bit to lose as well and needs to stick to their principles and really advocate hard.
Okay. Stephen?
Yes, just one further thing in response to the Senator's question. I think your suggestion, Chair, of having a government statement for Day Against the Death Penalty, and to have that delivered from time to time by the Prime Minister or and perhaps different senior ministers is one way in which the policy can be seen as being reflective of the whole of government. And if that statement's done every year, it's a reinforcing of the strategy for everybody in government. So I think that's one way in which it can be reinforced and not just be something in the corner of some desk in DFAT somewhere.
An annual statement, as we do on so many other areas in Parliament.
Yes.
I'm going to ask a question in relation to emerging or known trends of particular groups overseas that are at heightened risk of the death penalty. Are there any particular groups or individuals that you can think of in other countries who are at particular risk or increasing risk?
Certainly, as we said, across the Asia Pacific, we have the war on drugs. So we have persons who interact with drugs, who use drugs, certainly quite vulnerable to this very punitive regime of mandatory sentencing in some countries around the death penalty. One of the big areas of concern that we flag in our submissions is Myanmar, where cooperation has been given in relation to drug offences between our police and Myanmar on, I think, about 296 cases, whilst they do have mandatory sentencing for death penalty in relation to drugs. So that's certainly a concerning area. But also in Myanmar, we've seen in the last 2 weeks, I think 2 weeks ago, political activists were executed. And there's definitely concerns on the ground in Myanmar for further executions to take place imminently. I think, the big thing is what we don't know. What we don't know is the numbers of executions in China, although we do know that that's the leading space for executions in our region. And we also know Iran. The number of executions, particularly drug executions, is absolutely skyrocketing and highly concerning. We also know that some of those charges are spurious charges, and people who oppose the government are given, these corruption on earth charges. So we know a lot of the executions that are taking place are well beyond any scope of most serious crime or kind of judicial process. I would kind of put them in the category of extrajudicial killing, really. It's gone so far. There's it is an area where we're continually reminded that you can't get complacent. Countries that haven't had it on the agenda suddenly do, or countries that look like they're abolitionists, like the government of the Philippines, who are abolitionists, but then during the war on drugs, have reported to have about 30,000 people were extrajudicially killed. Was I think the stat reported by Human Rights Watch around the war on drugs. So just if you only look through the lens of death penalty, you actually miss the amount of state sanctioned killing that's going on. So it's certainly an area that we can't be complacent on. I do want to say that the government, the Constitutional Court of Taiwan recently, 2 weeks ago, came down with a ruling where there was a challenge to the constitutionality of the death penalty. They did find that it was constitutional, but they have greatly limited its scope in terms of kind of adhering to the most serious crime. It's certainly not the progress that we as a community and certainly the activists on the ground were hoping for, but it is important, I think, to note that as well.
Anyone else like to comment on emerging known trends, particular groups at heightened risk?
Well, Shane,
in particular?
can I just say, if you look at those that are being executed, and I think the case in point is probably look at what occurred in the Philippines. Of those thousands and thousands of people that were extrajudicially executed, we're talking about the poor. These weren't the drug lords. These weren't those at the top end of anything other than just carving out a living. Without doubt, that the poor are at the sharpest end of the death penalty. The ones that can't afford proper lawyers, proper legal representation. There's as Senator Dean Smith were advised when we were in Malaysia, one of our times there was, if you can afford a good and competent defence lawyer, you won't be on death row.
I think I would...
Lisa, have you got any other questions you'd like to put?
I don't know if this was... I mean, this is sort of being covered, I think, in various ways, but maybe just in terms of like... I mean, there's so much, right? If we were to, get best bang for buck and key priorities coming out of this inquiry, like where would you say we should really focus our energies? Like that's quite a big question probably, but like just to help focus.
But highly relevant, Lisa.
Yeah.
Could I just say in that regard, Senator, I think the recurrent funding to organisations operating that space, which are value-adding Australia's policy position in terms of the death penalty.
Yeah, I think if I could...
Anyone else?
I'd like to, if that's okay. If I could just sort of go back a little bit to areas of concern, but also aligned with what Chris was just saying. I think that, and it somewhat echoes what Sarah was saying, but for us, really, Iran and Singapore are the really big countries of concern, and they're quite different in how they do it as well. So Iran it's blatant. It is clear, particularly the last couple of years, that what they are doing is they are trying to suppress dissent. They're trying to, the Islamic Republic of Iran is really just trying to have absolute power and to stop the protests and to, what we're seeing what we're really seeing recently is that a lot of women activists and human rights defenders are being given a death sentence, and again for the spurious charge of very vaguely defined national security offences. And there's other ways that Iran is really trying to limit women's participation in society and to and also what we were talking about before, that the flow-on effect is that it encourages the state-sanctioned violence. It definitely will encourage that by making women a target. But then, and so Iran is absolutely concerned. They're averaging 3 executions a day, and we can't even keep up with the statistics. But then Singapore is a really different example in that I think one of the questions put in the earlier session was, what do Australians in general think of Singapore? Australians in general have a really great view of Singapore. They don't see that, some people do know, but even when we've spoken to practising barristers that practice in criminal law in Melbourne, they don't necessarily know that Singapore is executing for a kilo of cannabis, that they have mandatory death penalty for very, very small quantities of drugs. And so, and part of that is Singapore it's similarly repressing, but so not allowing anyone to say anything against them and coming down so hard when they do, and using and abusing their laws to force organisations to put corrections notices up saying that what they said was factually incorrect when it wasn't factually incorrect. It was a difference of opinion to the government. And so...
Martin, you've got your hand up.
If I could step outside my role long enough to say this, in Iran they regularly use torture in order to obtain confessions.
Yeah.
And that is probably something that the Australian government might try and address. I mean, my knowledge only comes from writing submissions on urgent action cases for Amnesty International, and I'm sure Amnesty would have a good deal more to say about this. In America, of course, it's renowned that the people who are most susceptible to suffering from the death penalty are African Americans.
Yep. Okay. And now, in conclusion, anyone else like to make any comment as we come to the end of this session? You've been fantastic, can I tell you? And we really appreciate the evidence has been outstanding. So I really appreciate everything and everyone's contributed. Anyone like to make a sort of a closing statement?
If I could Martin's just reminded me that I was actually going to circle back around to what Chris was saying about the best bang for buck. I know we keep saying it, but the recurrent funding, like when we have time to not fight for our existence and to spend time on Iran and Singapore, there is a lot of momentum there. There's a lot of interest. We've been able to spend time more recently recording video statements to support No Execution Tuesdays in Iran, to put out a lot of awareness-raising information across our social media, and it's really gaining traction, and that's only been sort of the last couple of months of focus and work. And so just when that's what I can spend my time on, instead of trying to secure the organisation's future, we just go ahead in leaps and bounds.
And also,
Sarah?
similarly, kind of picking up what you were saying before about the idea of engaging with lawyers, engaging with judges, education campaign in Australia will really, I think, be able to affect what people think in terms of Singapore and that kind of, in legal industry to legal industry exchange, I think could be a space where there's effective change. But again, that takes resourcing. I think we're well equipped to educate. We've got the good networks and we've got the good resources. We just need the capacity to be able to do that. And I think, an engaged campaign with activists from around the world focused on this would be effective and regionally important. It's regionally important that the mandatory death penalty for drug offences is eradicated at least. Given the fact that so many people are sitting on death row for very small quantities of drugs, it's really that will have a really good effect.
Thank you. Anyone else like to make any closing statement? Like to add anything else before we close up? Well, thank you very much. Thank you for your time today. If you've been asked to provide any additional information, including questions or notice, please forward those to the Secretariat by Friday the 1st of November. Please note the responses to questions or notice will be published on the website as submissions to the inquiry. You will be sent a copy of the transcriptive evidence to assist you with answering questions taken on notice today, and you will have an opportunity to request any corrections to transcription errors. Thank you very much, and thank you for your willingness to participate in this inquiry and for the great work you do in forwarding human rights around the world. Thank you very much. I'll suspend this particular meeting and we'll resume at 1 p.m. daylight saving time. And I say
Thank you. Thank you very much, Chair.
Thank you. Good to see you all.
Thank you.
Thank you.
And ahead of Senator Smith joining us, I'd like to reconvene today's hearing of the Human Rights Subcommittee's inquiry into capital punishment, and I'd like to welcome witnesses who are giving evidence today from the Harm Reduction International and Harm Reduction Australia, and also Australian Civil Society Committee on UN Drug Policy. So I now welcome you, and for the Hansard record, would you please state your name and the capacity in which you appear before the committee?
Hi, my name is Ellie Morrison. Shall I start, Albert? And
I will we'll get everyone to put their names on record first, then I'll ask you for opening remarks.
Great, okay.
Just
So my
name
name's...
where you're from. Yeah.
I'm Ellie Morrison. I work for the Australian Injecting and Illicit Drug Users League, and I'm representing Australian civil society that also includes some international people in that group.
Okay, and next.
Albert?
Hi, everyone. Hi.
Sorry, say that again, Albert. Yep.
My name is Albert Wirya. I'm the director of Lembaga Persatuan Masyarakat.
Okay. Thank you. For the Hansard record, this hearing is a legal proceeding of the Parliament. The giving of false or misleading evidence is a serious matter and may be regarded as the contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Do we have any overseas witnesses? No. Okay. Now, I now invite you to make a brief opening statement before we proceed to discussion. Thank you. Al, do you want to go first?
Yeah, thank you. Thank you for the opportunity to speak today. So, as I said, my name's Ellie Morrison. I represent the Australian Injecting Illicit Drug Users League, and I'm part of a civil society group that works in the works with the Commission on Narcotic Drugs.
Yep.
So we have submitted to this inquiry with the International Drug Policy Alliance.
Mm-hmm.
And we work to highlight the importance of the human rights and dignity of people who use drugs.
Yep.
So the Human Rights Commission has clearly stated that drug offences do not meet the criteria for most serious crimes, yet 34 countries still enforce the death penalty for drug offences, with drug crimes accounting for almost half of all known executions, or 42% of executions globally, a number that continues to rise year on year. And although Australia does not use the death penalty for any crime, and nor do we support it, we're also known as a world leader in harm reduction and health responses to drug use.
Mm-hmm.
Yet in the Joint Standing Committee's report on abolishing the death penalty, only one of 13 recommendations was rejected, and that was recommendation 3. So this recommendation would require the Australian Federal Police to obtain guarantees that the death penalty won't be pursued before sharing information that could lead to executions. It was rejected because interrupting drug supply was seen as more important. When we share information that we know could result in executions, what does that say about our values? Rejecting recommendation 3 and the subsequent actions of our law enforcement agencies speaks as loudly as any of the words we say about abolishing the death penalty, human rights and justice.
Mm-hmm.
If we want to influence global efforts to end capital punishment for drug offences or any crimes, our actions must align with our words. Only then can Australia continue to be credible advocates to end the use of the death penalty for human rights and justice.
Mm-hmm.
Thank you.
Albert, do you want to say anything?
Yes, for sure.
Thank you.
Good afternoon, everyone. My name is Albert Wirya. I'm the director of Lembaga Persatuan Masyarakat for Community Legal Aid Institute in English. Our organization is a human rights organization based in Jakarta, Indonesia, that provides legal services for death row prisoners. Currently, we are representing.
Albert, it's Shane here. There's something wrong with your volume. It's muffled. It's very muffled. It's like there's a problem with the actual
sound,
the audio stuff.
Is it better now?
Yes.
Maybe I just need to speak more loud. Yeah, currently, we are representing 10 clients on death row from various nationalities. As an organization working on the ground, I can testify that the support from development partners and the international community is crucial. Due to public pressures and constant advocacy, Indonesia has imposed an unofficial moratorium on executions since 2016, 1 year after the execution of the Bali 9. The continued conversation and advocacy also encouraged the Parliament and the government to revise the criminal code, which will give chance for death row prisoners to get communications. Death penalty is never just, neither the justice process nor the selection of who will be executed. It is all political and marred with blemish. Certain people will be more likely to be sentenced: foreign nationals, poor people, migrant workers, people with disabilities, and people who use drugs. The system makes it difficult for death row inmates to get information regarding their rights and for their lawyers to advocate for their rights. Therefore, please do not heed the promise that a retentionist country will guarantee due process of law for criminals who are extradited to a country. The existence of death sentence itself is proof that the criminal justice system is compromised, that the criminal justice system is designed to structurally discriminate who will lose their right to life. Rather than working with criminal justice system in retentionist country, it is important that Australia needs to strongly advocate for abolition in the region and support the abolitionist movement in the region. Thank you so much.
Okay, thank you. Look, I'll kick off. There's a series of questions that we'd like to ask, but I'm going to ask you if you could tell us a little bit about the views of the public in the countries towards the abolition of the death penalty, of course, in the countries, in the retentionist countries that you operate in. Is there a growing movement against in favour of the abolition of the death penalty? Has it stagnated? Has it regressed? Can you shed some reflections on that?
Yeah, sure. We did research back in 2019 to 2020 with Oxford University in Indonesia to understand public perceptions on death penalty. And while we see, the result shows that the number of people who are supporting death penalty is still majority, more than 50%. We see that the support decrease when they know more nuance of the case, whether the case can contain evidence of unfair trials or if there were other alternatives given to the defendants rather than sentencing them to die. They choose for a rather lenient punishment such as imprisonment. So from this data, we gather that although not all of the people support the abolition of the death penalty, with continuous support and continuous education is possible to persuade the public to also reject the death sentence and death penalty in a country.
Can I just on that issue? So the support for the death penalty amongst those who do support it, is it because does it relate to specific kinds of crime only? And if so, in terms of the belief that people need to pay, such as the seriousness of the crime, that they need to pay with their own life, which crimes would they be? And whether there's any discussion around, I mean, obviously, the whole issue of drug use and drug possession as well. So do they believe in the death penalty equally for murder as opposed to possession of drugs or selling of drugs? Are you able to distinguish at all in that space?
In that research, no, we did not specify which kind of crimes do you think is more appropriate for death sentence. But we saw that there are many sentiments on at least three issues that we see in the daily conversation. Mm-hmm. So the first one, of course, murder and brutal murder involving multiple victims or involving intimate partners or children. We usually get more sentiment for support for that sentence. Drugs offense, yes, also, but it usually involves with for drug mules or drug producers who carry or who are being found with large amount of drugs, heroin or methamphetamine or even marijuana, get that kind of sentiments. And the last one, I think, corruption. So under under Indonesian law, certain acts of corruption can also be sentenced to that. And the public sentiments regarding it is usually very strong, and sometimes it's being used politically for other people to gain electability or popularity. The person or the candidate can promise to provide that sentence for corruption cases. So I think those three crimes gave the most strong sentiments of support for that sentencing.
Is that because corruption is an interesting one? The attitude, so in our country, and there's also an attitude and a belief in rehabilitation and the ability for people to reform their ways and to be allowed the opportunity to go back into the community. And there's less fear about, people who've spent a long time in jail for very serious crimes. There is an acceptance and an understanding that at some point they've paid the price and are rehabilitated. Is a similar sentiment? Does a similar sentiment exist towards punishment, or even in the discussions that you have around punishment itself, shifting from death penalty to, imprisonment and then rehabilitation? Is that an attitude that exists in the countries that you operate in, or is that just doesn't exist, rehabilitation?
Well, unfortunately, the perspective on rehabilitation and reintroduction of criminals to society itself is not being acknowledged by the public. Although the process of the penitentiary system we have here in Indonesia obviously directed to that purpose. That's why the prison system itself is also built much on rehabilitation and giving opportunities for people to parole or to assimilate to the society. But I think the sentiments that we gain here is more that the imprisonment itself sometimes can be used by certain people, certain powerful people, to escape or to not getting the punishment that they deserve. So in terms of again, like corruption case, there are many incidents where corrupt individuals can have a more specialized treatment inside the prisons, and then they will also serve for a short period of time, depending on who view it, and then be released and back to the society with less rehabilitation that they should receive. So unfortunately, this kind of statement that are being perceived by the society regarding certain cases and might also been happening to cases of drug cases in which there are many incidents where people inside the prisons can still deal with drugs. So that's also bringing the sentiments for people, for the public, that there is no purpose of rehabilitations in the process of.
Yeah, I'm having trouble with the audio. It's mumbling all the time. It keeps coming in, coming out, coming in, coming out, coming in. I can hear bits and pieces, and then all of a sudden it stops.
We'll try and Pacific. Can you, if you can try, Albert, to try and refine. Maybe you need to turn your that's what they tell us, turn your camera off if the sound isn't any good. Just one more question before, see how that goes. One more question before I go to Mr. Newman. On that whole issue of advocacy, in retentionist countries, is public advocacy, which obviously you are also involved in, as important as the government-to-government advocacy that takes place, as well as the organisational-to-organisation advocacy? I'm trying to get an understanding of whether there is a strong element of public advocacy as such and separate to government and organisations.
I think both advocacies are very important. Both are complementary to each other. The the civil society organizations that works on the ground to provide legal aid service, legal representations for death row inmates, and also to encourage the prison department, the justice system to provide the rights of death row prisoners must be complemented by government-to-government dialogues, because that's what we saw in 2016 when there was an unofficial moratorium. Suddenly the execution stops, and we believe that one of the major influences that are there are many foreign countries, there are many international communities that speak up regarding the execution process. And I believe that the same kind of approach might be also relevant to other countries in the region, such as Singapore or Malaysia. So I believe that those two should come side by side because those support each other.
Mr. Newman, would you like to ask some questions?
Yeah, I'll ask some questions.
Yep.
What are the risks for Australia in advocating for the abolition of the death penalty, both internationally and regionally? Do you see any risks for us doing so?
I think this is something that we are seen as being really strong on, that it's something that we're respected by many of our partners for doing, and that it's something that we need to continue to do at least as strongly as we have been, if not more so. And that means adhering to the values that we show our own citizens and talk about a lot, that we need to be seen as not being hypocritical on something as important as this.
And what are the opportunities, both internationally and regionally, or globally and regionally, that we have in this space? So you can think of any countries in particular and opportunities for Australia to have any influence, and if so, what should we do?
For us, absolutely, the countries that Albert's already identified, where the use of the death penalty for drug offences is incredibly common. That's mainly the Asia region, including the Middle East, but also Singapore and the Philippines, Indonesia, countries that we have very strong diplomatic relationships with, countries that we trade with. It would be an incredible opportunity to use our influence in those spaces to work towards abolishing the death penalty in those countries. Albert, did you want to answer that?
No, yeah, I completely agree with that, and I believe in Asia Pacific, in which Australia has more influence and good relationship. I think those are the countries that might be suitable for targeting.
That's great, Albert. I can hear you much better now, mate. I don't know what you've done, but it's improved it a lot. So are there any emerging trends that you can see of any particular groups that are at the heightened risk of the death penalty?
Well, I think in the region, there are a high risk of foreign nationals, especially coming from China, Taiwan, or the African countries that also being implicated for drug offense. And we also note in our submissions that foreign nationals are being discriminated, and because if they coming from some countries that are being perceived as wealthy, then they will become the object of corruption. They will become the subject of extortion. But while if they are coming from countries that are perceived as not that wealthy, then their rights are usually being abandoned. So I think it's both unfair for these two groups. And we saw that also foreign nationals could not get proper translations, although they said that they have English translation, but the English translation is not good and not are not capable to translate legal terms. And we also saw that there are many obstacles for embassies in countries to provide communications or to assist these individuals. So yeah, I think those are the things that maybe we can do together.
I would add to that people from ethnic minorities in some of those countries where they're particularly marginalised, and people who are migrants within their own countries can sometimes be particularly vulnerable to harsher penalties, including the death penalty.
Now, some of the other organisations have talked about the need for an aid program to support civil society organisations that campaign against the death penalty. And I broadened that out this morning to talk about other stakeholders that have various positions who might have more influence. And I gave a few examples of stakeholder groups in Australia that have a fair bit of influence, like the Business Council of Australia and the trade union movement and faith-based organisations, which may have broad views on a whole range of policy areas and are not necessarily concentrating on a one issue group. So, which you might see where, an environment group that wants to stop a rail line going through some area, So, to what extent are we doing things there, and how can we do it better? And should we be broadening out these civil society groups that might be able to influence public opinion in these areas?
I think it's really important for the resourcing to be adequate and to partner with organisations like Albert's in the countries where we want to have an influence, to have that local expertise and people who have really good connections and know what's going on. But the resourcing is super important, and knowing that the Australian government is backing the interventions that we're talking about, that there's that Australian support is very well known, being shown at the diplomatic levels, and that it's not just the civil society organisations, that we need to have that backing at the higher levels to go along with it. Albert, did you want to
keep going, Albert?
Yeah, I think that will be good ideas to keep expanding the networks or the coalitions that support abolitionist movement in the countries. You mentioned before regarding the trade unions, the environmental groups, the faith-based organization. In my experience, we also have tried to coordinate with them, and usually they also have good bargaining positions for the government and for the public to gain more traction in that. And also, we also work for example, with groups of workers, migrant rights, and they are also being very vocal on death penalty, because they're also.
Albert, we've got that broadcasting asked that you turn off your video so that it's easier to get.
Okay.
Yeah.
Because then I'm not alone in having problems listening.
Okay, good to know. Yeah.
You come in and sometimes I can hear you really well, and other times it's terrible.
Yeah.
So can I ask one
that.
final question, Chair? To come back to Albert's point about dealing, and I think it's your point too, dealing at the highest level. Some people have, including the New South Wales Council for Civil Liberties, are talking about developing a DFAT public strategy document. They're not alone. Other people have talked about that. Would you support that? And if so, what should be in that particular public strategy document, so that it's not just full of noble words and platitudes and, this is what we believe, what actually should be the strategy?
I would come back to our point that we recognise every one of the recommendations from our own parliamentary inquiry, including having the buy-in of Australian Federal Police and our own Justice Department, that all of the recommendations are taken on, and that we don't have exceptions to times we will actively participate in a case, share information that could result in the death penalty. We oppose the death penalty in any case that has any involvement or potential involvement from Australia, as well as that broader advocacy on the international stage. And I think the partnership with countries around our region in particular and the people that we have strong relationships with is important in that sense. But it's that cross-governmental support that it's from across not just DFAT but all of our agencies that are willing to cooperate with the recommendations that our own citizens believe in.
So earlier today we had Human Rights Watch Australia talk about the fact that Australia's strategy for abolition of the death penalty should cover government-to-government assistance or police cooperation in cases that incur a death penalty. In other words, we'd be in a situation where there would not be that cooperation wouldn't take place. But I asked this question earlier. In other areas, notwithstanding we could take a principal position there, in other areas such as transnational crime, drugs, pedophilic activity, people smuggling, etc., we would still. You would suggest, would you not, that we continue to cooperate with Australian Federal Police and other security agencies, with other security and police agencies elsewhere in relation to those matters, provided it doesn't come across matters that concern directly the death penalty. Is that your position?
Yes, and I think there's almost always an option that if it concerns Australia, that we deal with issues that come to our own borders. If it's something that concerns another country, then I don't think that we have the right to allow things that we think are against our values and actively participate in something that would go against our values. So we could participate to the point that we know it's not going to result in someone being executed.
But can I just on that issue, because that's a very vexed issue and it seems to be a fundamental problem too, in terms of our own reputation and our own, walking the walk, the talk. How do we balance? I mean, clearly the AFP and, they operate at a level of networks in the region, criminal investigations, trying to not only stifle or disrupt drug networks, for example, for our own safety as a country, but also in the region. How do you balance that if their work could potentially be compromised? I know this is a very difficult question, and morally too, to be honest with you. So I don't know what the answer is, but obviously you think about it quite a bit. I mean, there is a point where it's got to go one way or the other for the greater good. Maybe you can justify it. The greater good in this instance is protecting life, but that could also mean protecting much greater numbers of people in terms of... The
moral equivalency argument. That's the difficult one.
Can we have a bit of a chat on that?
Also, Maria, Chair, also the issue is to what extent, I mean, if we're dealing with some of the things I listed, it becomes very easy for that to fall into the area of directly, in some jurisdictions, issues that deal with the death penalty. It becomes very easy for that. It would cause a lot of difficulties for our AFP in particular.
I would love to hear what Albert has to say about this. I don't also have the answers, but I would be very happy to take it back to some of the colleagues in the civil society group that I work with to see what they have to say about that. But I think given that we're able to manage those questions in Australia, we should be able to manage them internationally also.
But it would be good if you could have further discussion on that, because that helps us as well, so that we're actually realistic about what we're doing to protect our reputation and our advocacy as well as our security. Albert, do you want to add anything to that?
Yes, thank you. So I think that's a very good question, and I might not have the straight answer for that because, you're right, it's a moral questions, and there are many ways to see it. But I think also to strengthen our points of recommendations to cooperate with the countries, not only to make sure that the countries do not apply a death sentence for this offense, but also to ensure that the countries that are being cooperated also fulfill the right to fair trials for these defendants, including appointing good lawyers or competent lawyers who are being able to ensure that at least the right of this person will not be suspended. Because we also saw that the opportunity, the risk of someone getting death sentence, at least in Indonesia, will decrease if they have a proper legal aid since the beginning of police investigations, when the lawyers can provide evidence, can support them during this crucial process. So, of course, you need to collaborate with the region. And another thing is, I think, what might be ways to prevent death sentence, but also to uphold the obligation, the duties to fight crimes. Is I think the Australian government also can try to link not only with the national police in here, but also the national CSO before the case are being referred. So I think like the case of human traffickings or the case of other sexual traffickings, there are many Indonesian CSOs working on that issues as well, and they have the capabilities of assisting not only the victims but also the families of victims, and they might also have a say in that regard, and they could also provide you with the possible leeway to prevent the harshest punishment, which is the death penalty, to be given to this person. So I think those are the steps that we can also try to do.
Just to go back to the initial discussion that we were having around crime and punishment and the nature of it, I just want to get an understanding. Is it fair to sort of assume, well, not assume, but the picture I get is that on one hand, the death penalty is supported in retentionist countries because it's seen as a deserving punishment for a horrendous crime. Generally, that's how it sort of works. And from what you've said, Albert, the whole concept of the prison system and rehabilitation doesn't seem to be, it seems to have this notion of a place of punishment and a place of corruption, and there's no guarantees of genuine rehabilitation because of that corruption. I just want to understand, is that the norm? Is that the way the public sees the penal system and punishment? And because it goes to the nature of how much advocacy you can hope to be successful in relation to changing people's attitudes towards using capital punishment as a form, capital punishment as a form of punishment. I'm just trying to get the temperature on that in retentionist countries. Is it an area that because if you start to reflect on the corruption of prison systems in retentionist countries and failure of any system that resembles any capacity for rehabilitation, you might also be straying into some diplomatic hot water about casting aspersions on other countries. And I'm talking now about Australian advocacy, by the way, and whether that is the sort of advocacy we can take up and if it has any purpose.
Yeah, I think many people in Indonesia see the penal system as broken. So for some people, it seems too lenient for certain crimes, but for the reformists, we will also say that it is too harsh for certain people. But I think that this is a problem that is being recognized not only by the public but also by the government. Because in many retentionist countries like Indonesia or Philippines, we also know that there is a problem with our prison system. It's too overcrowded. It needs to be reformed. And we also keep devising an alternative ways possible for us to deliver the punishment that criminals deserve, and also the benefit for the society. Like I know that the Australian government also invests a lot in restorative justice scheme, for example, in Malaysia. And I think that's one of the ways to at least fix certain parts of the penal system, and through that activities and other advocacies to reform the prison system in here, and to ensure that all of people who are being detained get their rights. I think slowly but sure the public perception on the penal system itself will be much better, and then and that will in theory will also help the public perception on that penalty as something that is unnecessary, because we have a more stable, more secure, and more efficient penal system.
Has there ever been any interaction within the civil society organisations of exchange of information around our programs, our post-prison programs, our juvenile justice programs, just the way that we run our rehabilitation, our attitude towards imprisonment? Has there ever been any exchange of discussion around how we, the Australian way of dealing with the whole business of crime and punishment and the nature of it with like-minded organisations in retentionist countries? Have you ever had those dialogues?
In my experience, I haven't been involved in that kind of dialogues. So, though we talk a lot about, restorative justice and rehabilitation system, it's very limited.
I'm aware of quite a few programs that Australia has had in the past, and possibly continuing, particularly in relation to harm reduction and HIV and law enforcement and health partnerships. So in Indonesia, as well as across the Asia region, there's been quite a few AusAid and Australian Development Program funded programs that would support local civil society and partner with Australian organisations to look at how law enforcement responds to drugs and to rehabilitation and legal systems. Yeah.
And my final question to you, Al, then is it worth providing more support and encouragement of that sort of interaction?
Yeah, I think because we do also continue to have a strong presence through the AFP in different countries in the region, that it's very important to combine that with health, because they do have crossover, particularly in relation to drugs and bloodborne viruses, but also in other aspects of people's lives and potentially with the death penalty. So I think that is something that we could do effectively. Yeah.
Thank you. Well, thank you for your time today. If you've been asked to provide any additional information, including questions on notice, please forward it to the Secretariat by Friday the 1st of November 2024. Please note that responses to questions on notice will be published on the website as submissions to the inquiry. You will be sent a copy of the transcript of your evidence to assist you with answering questions taken on notice today, and you will have an opportunity to request corrections to transcription errors. Thank you.
Thank you so much.
Thank you.
Thank you.
Okay, are we ready for the next? Yep. So I now welcome the New South Wales Service for the Treatment and Rehabilitation of Torture and Trauma Survivors to give evidence today. For the Hansard record, would you please state your name and the capacity in which you appear before the committee?
Yasmina Bayraktarevich-Hayward. I'm the Community Services Coordinator at the New South Wales Service for the Treatment and Rehabilitation of Torture and Trauma Survivors.
Thank you. Yasmina, and?
Good afternoon. My name is Rebecca Deal. I'm the Policy Assistant with New South Wales Service for the Treatment and Rehabilitation of Torture and Trauma Survivors.
Thank you. This hearing is a legal proceeding of the Parliament. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you very much. Thank you. So, overall, Stats would like to thank the Human Rights Subcommittee for the opportunity to appear at today's hearing, and we wish to start by acknowledging the Ngunnawal people as the traditional custodians of the land we are meeting on today. We pay our respect to the continuing connection to land, water and community, and to the elders past and present. We come to you from Darug country. STARTS is a non-profit organisation that has been assisting refugee survivors of torture and trauma rebuild their lives since 1988. Most of our clients arrived to Australia under the Refugee and Humanitarian Programme or have sought asylum after arriving. Many fled their countries of origin as they were at risk of death penalty and other forms of serious human rights violations due to their sexual orientation, gender identity, ethnicity, religion and or political beliefs. We commend the Australian Government for the steps it has taken and continues to take to advocate for a world without death penalty. Our submission to this important inquiry focused on addressing the heightened risk of death penalty based on political opinion, sexuality, gender, race and or religion. As a country that has abolished the death penalty, Australia is obliged not to remove anyone. We believe Australia is obliged not to remove anyone to another country if there are substantial grounds for believing that they may be subjected to death penalty. However, we are concerned that flaws in Australian refugee status determination process may unintentionally increase the potential risk of deporting people seeking asylum to the very dangers that Australia is working to eradicate globally. To truly lead by example, we believe that Australia's domestic policies should align with the values it promotes abroad. This means strengthening the refugee status determination process to ensure that it is fully trauma-informed and considers the complexities of persecution based on sexual orientation, gender identity, religion, ethnicity, and or political beliefs. While every person's experience of trauma is different, exposure to trauma can structurally change the brain, including areas responsible for memory, emotional regulation, and executive functioning. This can make it difficult for people to fully engage with the process of refugee status determination and provide consistent accounts of their experiences. Without a trauma-informed approach, the refugee status determination process may risk re-traumatizing individuals and result in erroneous negative decisions. Beyond the death penalty, it is important to note that people from refugee and refugee-like backgrounds can face a variety of other grave threats to their lives and safety, including extrajudicial killings, torture, persecution, and arbitrary imprisonment. This further reinforces the need for a robust, trauma-informed and fair process with access to legal support provided from the outset. Through our work in particular, we have seen how vulnerable certain groups are to the flaws in this process, including the LGBTIQA+ asylum seekers and those failed under the fast-track system. For LGBTIQA+ individuals, seeking asylum in Australia often comes with added burden of proving their sexual orientation or gender identity to decision-makers, who may lack the necessary understanding and training to assess their claims accurately and sensitively. We are concerned that the systematic failings of the fast-track process have also resulted in inconsistent and flawed outcomes. Thousands of fast-track asylum seekers have no viable or accessible pathway for permanent residency, with many hailing from countries that use death penalty to suppress dissent and maintain power. We have witnessed the devastating impacts that delays in processing and prolonged visa uncertainty can have on an individual's mental health and worldview. Facing lethal hopelessness, perpetual limbo, and years separated from their families, many are what the literature has called the advanced stages of feeling mentally trapped, boxed in, and especially hopeless and helpless. The research shows that people stuck in this limbo often experience heightened psychological distress, including suicidal ideation, psychosocial challenges, poorer resettlement outcomes, and again, even structural changes to the brain. These findings show the importance of getting the process right to ensure that people are not left in the vulnerable state for years and addressing this issue through establishing viable pathways to reassessment and permanent residency. This is both about protecting lives as well as upholding the values that Australia stands for. So in closing, we thank the subcommittee for the opportunity to appear today and present our concerns. We ask that careful consideration is given to the systematic issues within refugee status determination process and specific vulnerabilities faced by LGBTIQA+ individuals and those who refuse protection under the fast-track system. Strengthening the refugee status determination process through consistent trauma-informed practices, providing access to legal assistance, providing LGBTIQA+ competency training to decision makers, and reassessing those who failed under the flawed fast-track system are not only practical steps, but necessary ones. These actions will safeguard those in need of Australia's protection and also reinforce Australia's commitment to addressing the heightened risk of death penalty based on sexual orientation, gender identity, political beliefs, gender and/or religion. So thank you very much.
Thank you. I want to go straight to some of the things that you've mentioned in relation to the fast tracking, and can you give me some indication, because I'm very familiar with a lot of this. I deal with a lot of people who are going through the fast track process itself or who've been through AAT, appeals and ministerial interventions and so forth. Can you give me some idea? Do you know how many people who either have been refused refugee protection as refugees, or have been returned from those two countries where they're retentionist countries, or to countries where they face possible death penalty punishment as a result of their sexual orientation, their gender. I'm familiar with the political and religious, but the other two, I don't seem to, in my experience, I don't know whether there is data or numbers. Do you have any of that information?
I don't think the data is collected by anyone. So what we are talking about is rather the risk of death penalty upon return, as opposed to actually knowing. Because you've done research, and I don't think there is data available.
That's correct. In terms of the data, I understand that the Australian government doesn't track people that have been returned. I also understand that the Australian government doesn't track the number of people who have lodged protection claims based on those issues, and that makes it difficult to then sort of assess how many people have been refused. But through our work, we certainly have seen a lot of clients who have been refused, who have sought protection because of their sexuality and gender.
They've been refused on the grounds that they were not able to make a convincing argument.
Yes.
Yeah, and I think a lot of the time for people who are making sort of protection applications based on their sexuality or gender, for example, the biggest issue that I think we've seen is relating to credibility.
Mm.
And you feel that what's the balance between the system that is not, as you've described, trained enough, even culturally or sensitively, to ascertain the nature of the claim, in this instance of persecution because of gender orientation or sexual orientation? What's the balance between that, which means then you need to look at the system, and you've outlined some very comprehensive ways to do that, and the fact that there is genuine no credibility in the claim?
It's difficult to address the issue of balance, I guess. However, the system is flawed in many ways. I think I'd like you to maybe have a look at Refugee Advice and Casework Service document, specifically looking at, it's a document for legal practitioners supporting LGBTIQA+ claimants. It sort of highlights a whole lot of issues with the process, issues to do with culture and ways of describing one's sexuality in different languages, issues to do with understanding of Australian queer culture and the expectations and stereotypes the decision makers have made around online apps, around gay bars, drag queen scene, all sorts of things. It raises issues of the fact that people are often have lived in fear of revealing their sexuality or gender identity, and are very good at keeping it quiet and attempting to pass for something they're not. So, the credibility has been questioned based, again, on people's lack of knowledge of queer culture, on people's presentation and the expectations and stereotypes that go, with what does a gay man have to look like. There was someone who I know who is from an African country and loves soccer. And they were questioned as being a gay man, how do you like soccer and you don't know anything about RuPaul's Drag Race? So there were questions that were intrusive, the questions again that betray lack of cultural sensitivity in the context, lack of understanding of intersectionality of culture, race, language, gender and sexual identity. So there's a number of things at play, and I believe there's a greater chance of making a wrong decision and sending the person or denying protection to someone than the risk of someone actually obtaining protection.
So you referred to some report. You referred to some report that actually highlights a lot of those issues.
It's refugee case. Sorry.
I was just going to ask if we could send us a copy of it.
Of course, that's I've got it on here. Mm-hmm. So it's RAC's Toolkit, Guide for Legal Representatives and Community Workers. The other report I'd like to point you to is work of the Forcibly Displaced People's Networks, which is the peak LGBTIQA+ refugee organisation in Australia, and they have highlighted some of those concerns as well.
Okay, thank you.
A lot of the issues do appear to be inconsistent, I think, just from our work with people in the community who have lodged claims, as well as reviewing some of those cases that are available online. I think sort of different decision makers have come to different conclusions for the same kind of evidence, I think. So I think that just shows that the maybe training and knowledge isn't consistent across the board.
Yeah.
Okay, so obviously that's an area that needs to be looked at, and some sort of either recommendation or thinking around how we address that would be something that you would like this committee to go forward with?
Mm-hmm. Yes.
Yep. Thank you. So you deal with, I deal with, and Mr. Newman does too, we deal with Australia's great diaspora communities who come here, whether either as refugees or humanitarian program or as migrants, and they come and they live in Australia. They're always a great source of information for us, and we often see them as something that enhances and supports our bilateral relationships with home countries. So do you think that it is, if it were perhaps appropriate and safe to do so, should the Australian government engage diaspora communities in order to help us with our public advocacy for the global abolition of the death penalty? And if you think that that is a useful proposition, how do you think we could do it?
Absolutely. I think that would be an excellent idea. STARTS works closely with many diaspora communities, and as of last 12 months, we worked with diplomacy training program from UNSW, established by Jose Ramos Horta in the 90s, to work on developing advocacy skills amongst leaders in diaspora communities. We have also held a workshop with them on abolition of torture and how they can advocate against torture in their home countries. I believe there would be great interest in this. And there are many ways of engaging with diaspora communities, and we would be happy to provide any support if that was required. But there are other ways through, FECA, through SCOA, which are different peak bodies. Yeah.
Yeah, we engage with them all on a number of issues, but I don't think we've had very sort of significant engagement in relation to our own global advocacy against the death penalty. So that it's a good area to sort of focus and build upon. I'll go to Mr. Newman for some questions at this stage.
Sorry, if I may interrupt as well. Iranian community in particular is incredibly concerned, and we know that Iran practices death penalty, and we have worked closely with the Iranian community, particularly over the last 2 years with Women Life Freedom Movement, and where they talked about concerns of death penalty of people who are demonstrating.
Yeah, we're familiar with that.
So they would be very interested in working with you, I believe.
Yes, I know myself and Mr. Newman have lots of have appeared, the Iranian community, particularly its advocacy groups, have appeared before the Human Rights Subcommittee and other forums, so we're familiar with that. Thank you. Shane.
Thanks, Maria. We've had evidence today that, and this is a common thing, that organisations and civil organisations, including multicultural groups, often get funded from the federal government for projects or programs rather than core funding. So we've had evidence today that in this space of advocating for the abolition of the death penalty, perhaps organisations like multicultural organisations, legal organisations, advocates could be funded for core funding. What do you think about that?
I think that would be a fantastic idea. A long time ago, migrant resource centres across Australia had core funding, and on top of that, they've also received project funding. Their ability to actually maintain core funding also allowed them certainty, staff retention, and a long-term engagement with diaspora communities. So that core funding was very important.
It would allow you to have not just someone you put on for a project, but actually people with, there's an old-fashioned word, historicity, long historical knowledge.
Exactly.
You know, that knowledge of the area. I mean, we saw today, you know, Chris Hayes, and we've had Dean Smith, and I mentioned Graham Perrott and Maria Van Vakkenau, the chair of the subcommittee. They've had a long history in Parliament on this issue. Imagine if we had a lot of civil society groups with people who've been working in this space for quite a while, not because they've got a project, but simply because they've been funded to do a job like this for a long time. I think that would make a big difference. And I'm interested in your comments on that. What kind of difference would that make to an organisation like STARTS?
Look, personally, I have worked at STARTS. I came to Australia as a refugee in '93 from Bosnia. I've worked at STARTS since 1994. So 30 years this year. So I certainly have that historicity. And what that has enabled me and other people at STARTS, we actually have core funding from Department of Health. And what that has enabled torture and trauma services across Australia is to maintain highly skilled staff, to maintain staff who can be involved in advocacy and service delivery over prolonged periods of time, develop expertise, and grow the organisations. I mean, you probably all have heard of Paris Aristotle, who has led the Victorian Foundation.
We all know Paris.
You know Paris. Our CEO, Jorge Roche, has been at STARTS since 1989. So because we have that core funding, it allows us longevity, it allows us engagement with Australian government on many different topics, including our last year's recent funding from DFAT to bring Ukrainian mental health professionals to Australia to learn from us and for us to learn from them. So it allows us to create and build new and innovative approaches. On the other hand, we see organisations that don't have that core funding, and we can see the struggles. I write a lot of funding submissions for refugee-led organisations, and many of them recent Afghan funding that went to Afghan-led organisations was 18 months. That allowed them to set up, to employ skilled staff, to rent venues, to deliver services to Afghan community, to support them in following the evacuations. 18 months passed, that funding disappeared. Suddenly, we had organisations that actually built a client base that had hired properties from where to deliver the services, and that have been able to assist hundreds of people, and they had to stop. They reapplied for SETS funding, which again meant an interruption in service provision, and it meant that not all Afghan organisations received funding. So I'm with you 100%. I think I might have contributed to various government inquiries on this very topic and have written submissions myself.
Yeah, I think Rebecca and Jasmine, you've really outlined this quite well, because, you know, the core work you do on health and integration on refugee communities, if we saw this as our principal position as a country, the abolition of death penalty, as core to the kind of work you do, that would allow that long period of time. Imagine if you could have, for example, community workers, lawyers working for your organisation that would work in this space with you as well. engaging with diaspora and then having contact with their home communities.
Absolutely.
What a difference that would make, rather than having to fight for some sort of programmatic or funding every so often on this particular project. I think that's a fundamental change that we could make on this committee. But I'm glad you've given us that evidence today. I'm very keen also to hear from you where you think there are opportunities for us, and we talk about an opportunity here, to advance through multicultural communities and linking back to their countries of origin this issue. Where do you see the opportunities? You can name certain countries, you can name certain groups. I'm very interested to see your response.
Look, it would be work with countries that still practice death penalty, and again, Iranian community is one that I think has history of both foreign interference, threats to lives of people here and overseas, as well as concerns of a death penalty in Iran. There are other communities. I think China is another country, and I know that we have to balance our economic and other, other relationships. But I do know that people in, say, Uyghur community would be very interested in having conversations about this. And I think the opportunities arise from a number of areas. One, that there is detailed knowledge of the situation on the ground, that there's a detailed understanding of the countries they've come from, and the risks that people might face and the reasons for these risks, but also on passion and commitment that human rights activists in some of those organizations demonstrate. And again, I speak from my direct experience with again, Iranians, Uyghurs, Alawaz community from Iran again as well, and others. I think there's a lot of passion, there's a lot of energy, and there's a lot of commitment. And I think they would welcome collaboration on this issue.
Now, you mentioned the Uyghur group, and that leads me to my final question, Chair. And that is the particular groups that are at greatest or heightened risk of the death penalty. Can you talk about those particular groups that we should be aware of as a country and as a committee in particular?
So when you look at the groupings, again, we spoke about people who are LGBTIQA+, and there is 6 countries where death penalty has been either done or people have been sentenced to death. In Yemen in January 2024, 9 men were sentenced to death, and then 13 further men in Yemen were sentenced to death for promotion of homosexuality in February 2024. So as a group, and in particular in relation to countries that both potentially practice death penalty or the death penalty could be something that can happen, there's an extra 6 countries. There has also been a recent report about Taliban treatment of people who are LGBTIQA+ as well, so we could provide you with that report. It does speak to a lot of these issues. So that's one group. But then you have groups like, again, Uyghurs, or Uyghurs as they refer to themselves often in China. You will have people who are political activists and people who are members of media, I think, in Iran, people who oppose the government in some way, but also ethnic groups in Iran, like Awazi. So we've consulted closely with the Awazi community, and they have raised concerns over death penalty and spoken to us about people who were executed from their community. Let's see who else. Look, if you go to Afghanistan, I don't know that we can do very much with Taliban. I don't know that there is anything that can be done there. But in Afghanistan, if you are a Tajik from Panjshir, if you are Hazara, you're at risk. If you're a woman who doesn't conform, you're at risk. If you're gay, you're at risk. There's multiple other countries that I think we could look at. And often it has to do with political opinion. Even if you look at the Russian Federation, and there are certain things that they might not be practicing death penalty as such, but there are certain activities that could put you at risk of extrajudicial killing, as we have noticed. And even living in UK might not save you from that.
It's a very interesting area, isn't it? Because so far we referred to countries that have the death penalty and use it for the violation of human rights in addition to presumably crime against individuals and property on the one hand. But then you've also got friendly countries and some of our greatest sort of allies, the United States, for example, that employs the death penalty, and trying to find a balance between advocacy in like-minded Western countries like the US that continues to use the death penalty, and other countries that have got, far more serious human rights abuses. How can we balance that? This will be my final question. I'm just interested in exploring this area because my view in terms of our advocacy has to be the death penalty itself should not apply across the world in any case, and there should be other methods of punishment.
Well, look, one of the first things that our colleagues asked us when we said we were coming to this hearing is to check with you what Australian government is doing with the US government on abolition of the death penalty. So that was one of the first questions I was asked. Look, in countries like, Iran or Afghanistan, it's used as a method of political control, as we all know, and it's a part of state terrorist. You look at the concept of state terrorism and its practice of state terrorism. And I think, it will be very difficult for me to give you any advice. I'm not sure Beck is there.
I'm just
take it on notice, I think.
Take it. We'll go home and think about it.
The person who asked you the question to ask it might have some ideas.
We might ask them, particularly on the US front. There is most of our submission that actually Beck is the author of has focused on not returning people to situations where they could be exposed to death penalty, because that's our area of expertise. But we might have some conversations with our staff.
There are other countries also that are retentionist countries that don't necessarily practice state terrorism. So I'm glad that we've made the distinction as well.
Definitely.
I don't have any more questions. Mr. Newman, do you have any more questions? Okay. Look, I'd like to thank you for your time.
Maria, I might have. I've come back into the room.
Are you online?
I'm in the room, actually. Yep, there we go.
Sorry.
Welcome. My apologies for... If I might just ask a couple of questions.
Sure.
My apologies for being delayed at another hearing. In your submission, you talked about the Australia's refugee status determination process. Could you just, and my apologies if you covered this off in your contribution already, I thought that Australia's non-refoulement obligations prohibited the return of people from Australia to nations where they could be put in harm's way, including but not limited to the death penalty. And I've always sort of understood and operated on the basis that was ironclad, non-negotiable. Is my understanding not accurate?
Would you like to?
I think the obligation is definitely sort of ironclad and non-negotiable, but I think in practice it hasn't always been the case. And as we mentioned, I think before you came into the room, the government doesn't track returnees and doesn't track what sort of happens to them when they are returned. So it's really hard to, I guess, provide that data to sort of evidence this is what's happened. But in our experience in the work that we do, talking about people who are LGBTIQ+ and sort of applying for protection for those grounds, we've seen sort of, I guess, flaws in the system where they've been sort of subject to inappropriate lines of questioning, and as you sort of mentioned, I guess assumptions about sort of the queer experience. And I think because of those flaws in the system, it has meant that people have been subjected to erroneous decisions, and then they're expected to depart.
And then the other one was, of course, the fast-track process, which the current government even recognises that there were issues with the fast-track process. And with that, that's a specific cohort of people who sought asylum. They didn't actually have the opportunity to articulate their claims sufficiently. And when they did, we also talked about the issue of trauma in the refugee status determination process. And with that, there's a couple of things that often, the decision makers believe might make people appear to lack credibility. Examples of that are, if you survive trauma, the way your brain remembers trauma, the way trauma is encoded in your brain is often not chronologically clear, because if any of my last traumatic experience was car crash on Anzac Bridge. If someone asks me to recall that experience, the first things that come to my mind are images and sounds. It's not subsequent. There is no chronological order in how I could tell that story. And that's due to how our brain encodes trauma. So if you're interviewed and if the parts of your story of trauma and torture and human rights violation comes in small portions, if it doesn't come in a way that's chronologically clear, if it doesn't come in a way that, if it changes along the ways, people might remember there's issues with traumatic amnesia, so people might remember certain things or not remember certain things and remember them later, which can cause the decision makers to question the credibility. If we have issues with one of the protection mechanisms in dealing with trauma is it's dissociation, and that's the thing where people often talk about out-of-body experience when sexual assault survivors speak of that a lot. What that is that people often divorce the emotional content from the cognitive content or storytelling content. So as a decision maker, what you might see is a person telling you the story without the emotion that you would expect, which again could lead to questioning credibility. And so there are many ways that many issues which largely have to do with how our brains process trauma that could lead to questioning of credibility. And it's... Yeah.
Sorry, don't just finish. I just wanted to clarify something that Senator Dean's asked a question around whether Australia has actually sent back, if I can correct Senator Smith, people that have been determined on shore. We don't send people back if they've been determined to be if they're issued protection visas for the reasons that they put forward. So we haven't done that. What I think the discussion here is trying to concentrate on people that are sent back because they're not found to have put forward a credible case for protection because of gender or sexual orientation or other political or religious dissidence. And you're describing to us how the decision makers who decide that the protection claims are not valid and therefore protection is not afforded and people are sent back, you're describing how that we're not very well equipped to understand all the nuances. And so that's what you're doing at the moment. But Senator Smith, I don't think we've ever I'm not aware that we've sent anyone back who was afforded protection on those grounds.
I would not have thought so. That's why I was curious. Yeah, that's right.
Yeah, and I don't think there is any data on that. Yeah.
Well, we haven't because, but there isn't. What you're saying is we don't know what might happen to people. We don't track them. They may be sent back because they haven't been believed.
Correct.
And to that effect, we're going to be sent a manual, I understand, that has actually got a lot of work. A lot of work's been done on guiding the legal system and others as to how to understand those nuances. Are there any other questions, Senator Smith?
Just briefly to make the observation, so it's good news that the number of retentionist states is declining. Yes. It's bad news that the incidence of executions is increasing, particularly in some nations like Iran and China. So, my expectation would be that if people were being denied, if their claim was being denied, and they would then, so if they make the claim and the claim is being denied, but they were of Iranian or Chinese citizenship, then that should be a powerful flag in terms of, extra caution or abundant caution. Does your work, the final question, does your work involve, supporting people who have been on death row and then they get, thankfully, released, and how they then adjust to normal life?
Well, some people would have been on death row in their countries of origin but they would have also been exposed to other abuses of human rights, including torture and other forms of cruel.
I was thinking more about
punishment.
Australians that might return to Australia having been on death row overseas.
We are not specifically established for that purpose. We did occasionally have clients who were in that situation. Yeah.
Final question, if I might just, Chair, I'm really curious about this. Often when people speak, they make an assumption that someone's ethnic heritage might actually predispose them to supporting the death penalty or perhaps not supporting the death penalty. Should we accept that?
No.
Agreed. Totally agreed.
Definitely not.
That every individual has a capacity to respect and want to uphold human rights, and in this case, the dignity or the sanctity of life.
Absolutely.
Absolutely. So we shouldn't make assumptions that, because a nation operates in a particular way, that the diaspora of that particular nation in our country should be less inclined to be interested in, less inclined to support abolition.
Yeah, and look, when you look at it, Australian society is full of people who have different political opinions, and I think, in any group of people you might find difference of opinion even on that matter, and the same applies to diaspora communities. So you're right, every individual has a potential.
Yeah, I just thought it was important to sort of put that on the record, because I think some people walk around making assumptions.
Yeah, no, we don't. Thank you.
Thank you. Well, thank you for your time today. If you've been asked to provide any additional information, including questions on notice, please forward it to the Secretariat by Friday the 1st of November 2024. Please note that responses to questions on notice will be published on the website as submissions to the inquiry. You will be sent a copy of the transcript of your evidence to assist you with answering questions taken on notice today, and you will have an opportunity to request corrections to transcription errors. And we've now concluded today's inquiry, so I'd like to thank committee members and witnesses for their time today and declare this public hearing closed.